Lord, item 15, 16 and 17. This is that matrimonial matter, my lord, where we were supposed to sit down and face to face and settle.
And it has been possible, my lord, that we have sat together, both the parties. The petitioner had come all over from Delhi, Bangalore, my lord, and they have come to an understanding, my lord. In fact, an agreement has also been executed between the parties, which is in my friend's custody, my lord. So at least to get the groundwork done, my lord, we are praying for 3 weeks' time, so that whatever has been narrated in the settlement agreement, my lord, may be given effect.
You see, I think under the circumstances, what you can do, you have to understand that this proceedings before this court is for grant of pre-arrest bail. What you should have done now is to approach the trial court, get the matter sorted out.
Yes, my lord, we'll do that.
And perhaps the relevant FIR, complaint, everything may be withdrawn or whatever.
We'll do that.
And then,
We'll
as far as this matter is concerned, nothing survives.
Nothing survives, my lord. What we'll do is, my lord, before the next date, I'll bring the settlement on record, just for the perusal of this honorable court, and then everything will settle down, my lord.
And in the meantime, the obligations of both the parties may be carried forward. So we are praying for 3
Yes,
weeks' time.
that you see, what you have to do on your own, do it. In fact, it would be better if you can get the matter resolved at the trial court's level,
Yes, my lord.
or whatever, and then get a corresponding order from there.
Yes, my lord. Definitely. We'll do that. 3 weeks, my lord.
3 weeks, ma'am.
On pre-made by parties, this is matter to 3 weeks.
Deeply obliged.
Wait, please, Your Lordship. I'd like to mention item 11, my lord, for next week, subject to Your Lordship convenience.
You're for?
I'm for the petitioner.
Any private respondent?
No private response. State is the
2 weeks. On pre-made by the petitioner, this is matter after 2 weeks.
May it please Your Lordship, I'd like to mention item number 7. Before 2 weeks' time, as we are yet to connect to the respondent number 6. She's beyond reach.
What is the this matter is posted for
Hearing, my lord, regarding the appointment, lordship,
appointment?
selection process.
Yeah. So
We're taking time, my lord. We have no objection.
you're for?
Respondent number 6.
Who's respondent 6?
She is the main contesting respondent, my lord.
She was empaneled as the subject expert.
Oh,
in the
that Hindi Garo. But your role will be subjective.
No, why, my lord? Because the petition is directed towards her position as a subject expert in the interview.
Yes,
So
but-
she has to.
She's not from the
But the onus will be on the government,
subject.
on the department rather.
Lordship. In fact, there are no specific rules, at least to my knowledge, my lord, as to how the interview board is required to be constituted. Anyway, my lord, it may come up for hearing once.
Any stay order in this?
No,
No.
You have not been appointed.
no, my lord.
The previous respondents have been appointed.
That's why I was asking who's the private. You have
I am for the petitioner, my lord. There was no stay.
711. You're also 7.
No, 6.
You're 6. On pre-made by the respondent number 6. Not objected to by petitioner. This is matter to 1 week.
Please, Your Lordship, I beg to mention item 19 to 21.
21. 19.
Therefore, responding 1, 2, and 3.
Yes, what is this matter?
It's a criminal petition. The conducting counsel is out of station, Your Lordship. I'm praying that this matter may be adjourned for today.
On pre-made by the petitioner, on the ground of indisposition of the learned conducting counsel, senior counsel, matter is adjourned. Decision of the 3 weeks.
3 weeks.
I will batch.
Your Lordship, I beg to mention item number 18. I am representing on behalf of Senior Counsel M. Deb. My prayer before this humble court is if this matter be taken on the 29th or 30th of this month, Your Lordship. I've taken the consent of the learned Senior Counsel.
Yes, who's appearing for the respondent? You have taken their consent.
Yes, yes, Your Lordship.
On pre-made by the petitioner, list is matter to 2 weeks.
Much obliged, Your Lordship.
May I please, Your Lordship? Item number 22, Your Lordship. I am representing respondent number 4. Your Lordship, to submit my argument one date I required. Last date only I was appointed by the respondent.
What is this matter about?
This is 376.
Crossing of the affair.
What is the subject matter?
376.
376.
I have to take some more details from her so as to present my argument, Your Lordship. Just prayed, one date may be awkward.
You are the private respondent?
Yes, private.
I am the state respondent.
State.
1, 2, and 3.
On pre-made by the your respondent?
Number 4, Your
Understood. Pre-made by the respondent number 4. Not objected to by the petitioner. List this matter to 2 weeks.
Yes, oblige, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 12. I'm appearing on behalf of the petitioner. I kindly pray for 2 weeks' time.
On pre-made by the petitioner, list this matter to 2 weeks.
We please, Your Lordship. I beg to mention item number 9 and number 10, Your Lordship. I'm praying for 2 weeks' time, Your Lordship, as my senior is still undergoing treatment.
I'm appearing on behalf of the petitioner, my lord.
You are for the petitioner?
Yes, my lord.
Any objection?
No objection, my lord.
Prayer has been made for accommodation. On behalf of respondent.
In number 9, 1 and 4, Your Lordship, and 10, we are the for 1 and 2.
You are the cantonment board.
Yes.
On behalf of the respondent cantonment board, on the ground that the learned senior counsel is indisposed on ground of ill health, on account of ill health. As prayed for, that is adjourned. List is same after
2 weeks, Your Lordship.
2 weeks.
Much pleasure.
Supplementary cause list, item number 1.
Your Lordship, my senior is on leg, Your Lordship. So I pray let the matter be taken up tomorrow, Your Lordship.
Your Lordship, I'm appearing on behalf of Mr. Essen also, Your Lordship. He's also on legs, Your Lordship. They're
Let the
having
matter
the
be
same
taken up tomorrow, Your Lordship.
About the state.
On pre-made by the parties, list this matter to 1 week.
Obliged, Your Lordship.
Item number 1.
May it please the Lordship. As far as the status report is concerned with regarding to respondent number 1, 4 and 5, my lord, it has been returned and served, except for respondent number 2, my lord. We are yet to receive the service status report, my lord, in that case. If your Lordship may grant us kindly 1 week time in order to receive the status report upon respondent number 2, my lord.
Respondent 2.
Respondent number 2.
You are appearing for respondent 3.
3, Your Lordship.
So what about who is one?
One is the company, Your Lordship.
Company itself. So far, only respondent number 3 has been represented, my lord.
So you have not been able to effect notice on 1,
1,
2, 4
and 5.
and 5.
We have received the status report with regarding to respondent 1, 4 and 5 only, my lord, not here regarding the respondent number 2.
1, 4 and 5 you have received.
Received. It has been returned and unserved, my lord.
Return answer. So that issue remains that you have not been able to ascertain the correct address.
We have communicated, my lord, to the department. We're still awaiting instruction from the department pertaining to that, my lord.
We cannot go on like this. This court has time and again, has indicated
Yes, my lord.
that if we are to wait endlessly for the service to be completed,
This might be given as a last chance, my lord.
Ms. Letter Counsel for the petitioner has submitted that in spite of the best of efforts, the notice issued upon the respondents 1, 4 and 5 could not be effected as the same has returned with a note that the address of the addressee is unknown. In this regard, it is prayed that another opportunity may be allowed for the petitioner to try and find out the correct address and to take steps for issue of fresh notice. As regard the respondent number 2, the Learned Counsel has submitted that the notice upon the same has been affected, but you are yet to file the affidavit of service.
Yes, my lord.
And to this effect, the affidavit of service may be allowed to be filed in due course.
And Your Lords, there's for the query which we have said last date that we want to file some pleadings on non-appearance of other respondents. So within this week we will file our pleadings.
Ms. Learned Counsel for the respondent number 3. has, however, submitted that the respondent number 3 may be allowed to file by way of an affidavit certain facts and authority as regard the non-service of notice upon the respondents, on the other co-respondents. On pyramid, list this matter up to 3 weeks.
I just blanch one.
Item number 3.
Reserved. May it please your Lordship. Lordship, this is that 133 matter from Nongpo. On the last occasion, Lordship may recall, Lordship was pleased to allow the private respondent, number 5, one more opportunity to be present, but I don't think there is any appearance, my Lord. So matter may have to be decided on merits. We have just one legal point to raise, that 133 proceedings cannot be drawn up in a private dispute. And clearly this is a private dispute between me and number 5. So regarding number 5, my Lord, we have filed an affidavit of service also.
Mr. Khan, I believe you're supposed to file a status report.
Lordship, we had filed.
You have filed?
We had given a copy to them also. And so, Lordship, the last part of the status report was, the Lordship will recollect.
Yes.
Clause 9, Lordship.
Yes.
So that was not desirable, Your Lordship. My only respectful submission, Your Lordship, is this: if you recollect, in the last date we made a submission. If they could comply with that, then the case ends.
Comply with what?
Inspection found that the work done by the respondent is not desirable. So only we stop at that point, Your Lordship, on this particular issue. If they can say, submit, saying that whatever was asked by the executive magistrate has been complied, and then this matter can be closed. That is one aspect of the matter. And second aspect of the matter, Lordship, is this: the issue that he raised, and I also raised some legal issue. It is not a public dispute, private dispute. Lordship,
Yes, of course.
Lordship, there could be two situations.
It's a private.
It's a private dispute. Number 5, respondent number 5 filed a complaint against me. Based on that, the entire proceeding was drawn up.
And the land is also private land.
Private land. Both of us. Private land.
So nothing public. It's not a public drain kind of thing. Or
nothing. There is a drain between our properties. My drain. Allegation was the water from my drain is seeping into his compound. So I was made to do certain things in respect of that drain. I have done all of that. Lordship may recall that instead of pointing out what was the deficiency, magistrate instructed the police to shut down all businesses, etc., forcing us to come before this honorable court. Now, what Mr. Khan has submitted, that we may be directed to comply, because what the status report says is that the work done is not desirable. With respect to the executive magistrate, it's neither here nor there. Not desirable. At least I don't understand what does that expression mean, not desirable. But in any
desirable
event,
in what sense? Whether it has affected the, let us look at the letter of 133.
Lordship, I was on another point actually.
Yes.
I was on another point that in respect of compliance or non-compliance, I am not before this honorable court trying to agitate that I have complied. I am not on that, my lord. I am only trying to impress upon this honorable court that the learned magistrate did not have the power under 133 to draw up these proceedings in the first place. That power was absent from the first day itself. But not to complicate matters, I had tried to comply with whatever directions were issued from time to time. Directions were, first you cement up the drain. I did that. Second direction was you repair your neighbor's wall. There were some cracks in his wall. I was made to repair his wall. I did that. And then finally I'm told my work is not desirable. Now I'm not on whether my work is desirable or not desirable, or whether I have complied or not complied. I am only now before this honorable court on a very limited legal point, my lord, that 133 cannot be drawn up.
Let us read 133. What is
yes,
it?
Lordship, the subsection 1 contains the circumstances in which the power under 133 can be exercised. Now, in my humble submission, it is clause A, subclause A and subclause B, which is relevant for our case, my lord. So, if I'm allowed to read, my lord, the entire section, Number one, wherever a district magistrate or a subdivisional magistrate or any other executive magistrate, especially empowered in this behalf by the state government, on receiving the report of a police officer or other information, and on taking such evidence, if any, as he thinks fit, considers, subclause A, that any unlawful obstruction or nuisance should be removed from any public place or from any way, river, or channel which is or may be lawfully used by the public. Lordship, channel in this case would be that drain, which is the subject matter here, my lord. Subclause B, that the conduct of any trade or occupation or the keeping of any goods or merchandise is injurious to the health or physical comfort of the community, and that in consequence such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed, or the keeping thereof regulated, or it goes on, my lord, not very relevant for our case, my lord. Now, in case the magistrate, my lord, observes the situation under subclause A to be present, that is, there is any nuisance connected to any drain or channel, in that case, he can exercise power under subsection 1. In that case, he can order to remove such obstruction or nuisance. So, what I'm trying to highlight, my lord, is that the situations that are mentioned from clause A to clause F, the power is mirrored, is reflected from subclause 1 to subclause 6. So in case he thinks that there is any unlawful obstruction, etc., regarding a drain, then subclause 1, he can order to remove such obstruction or nuisance. Number 2, if he's of the opinion that any, under subclause B, if he is of the opinion that any trade, etc., is causing a public nuisance, then he can exercise power under the corresponding subsection 2 to desist. He can order to desist from carrying on or to remove or regulate in such manner as may be directed such trade or occupation, etc. Now, this entire matter has arisen, and this is very crucial, my lord, has arisen out of a private complaint. If lordship kindly looks at my petition, the first indication that there was a complaint is at page 21, my lord.
Yes.
Now, page 21 is a letter from the Deputy Commissioner of Nongpo, my lord, sent last year, September, addressed to myself and to respondent number 5. Now, with reference to the subject cited above, I am to inform you that the spot inspection will be held on so-and-so, and the spot inspection will be carried out by so-and-so, so-and-so, so-and-so. This is for you. So there was an intimation to us that there will be a spot inspection. If lordship kindly turns the page, this is subsequent the spot inspection. An order was passed. Now, this is, if lordship looks at the subject of this order, matter relating to the complaint received from MS River so-and-so, Rebhoy district, that is respondent number 5. So there was some complaint based on which the proceedings started, my lord. Then there was an order passed that you are to comply, etc. So what I'm highlighting through this, my lord, is that a complaint was filed by my neighbor against me containing certain allegations. Now, in that context, the matter proceeded, finally led to the last order which was passed, where the magistrate verbally directed the police to shut down all businesses. So two things, my lord. Firstly, original complaint was regarding a drain, my drain, and the fact that, and the allegation that water is seeping into my neighbor's compound. So if the complaint is regarding a drain, the power in that respect has to be exercised under subclause 1. That is, an order can be passed to remove such obstruction or nuisance. Instead, what is the order that is passed? Shut down the business. So, shutting down the business, my lord, the magistrate first has to be satisfied that the situation under subclause B is attractive, that the conduct of any trade or occupation or the keeping of etc., etc., is causing a public nuisance. Entire proceeding is conducted in respect of one situation. Order is passed in respect of some other situation. Whereas the trade businesses of myself and my tenants, 40 of them, were never in question, were never the issue, my lord. That is one part, my lord. Second part, and more importantly, I would submit, is, as I have highlighted, it is a private complaint. that is filed by my neighbor against me containing certain allegations. A private complaint cannot be the basis on which Section 133 proceedings can be drawn up. I will not take up too much time of this Honorable Court. I will just place two judgments of the Supreme Court in this respect, if Lordship allows.
Have you annexed a copy of the complaint here?
Lordship, on the last occasion also had pointed out, till today I have not received a copy of the complaint. What is the complaint about? I can only assume it is about the drain because the entire proceedings were regarding that drain. But till today, I don't have a copy of the complaint.
In these letters, or rather communication by the
yes,
authority
or
the
Deputy
Commissioner,
yes, my lord.
Nothing is indicated as to what is the nature of the complaint.
Yes, ma'am.
It is only with regard to an inspection to be carried out.
Yes, ma'am.
And thereafter, inspection carried out.
Yes, ma'am.
And reference was made to the drainage system.
Yes, ma'am.
Not properly.
Yes, ma'am. So it is only on the basis of the orders that have been passed from time to time does it become apparent that it is regarding the drain.
If at all a complaint has been made by your neighbor, for this Mrs. River Umthro service station.
Yes.
So then you will know from the contents of the letter whether it refers to private property or it refers to a public property for that matter, to which perhaps a spirited citizen has brought the same to the notice of the authorities, or pertaining to the private property of such a complainant.
Yes, my lord, in that respect,
would be
yes, the page 23, my lord, the order at page 23, that is from 8th December last year, just the first paragraph, my lord. Whereas it has been made to appear to me that you, as caretaker of so-and-so 13th mile so-and-so Burnihart, have failed to construct a proper drainage channel and also failed to take necessary action in preventing the flow of drainage water into the property of MS River Umthru service station, etc. So, obviously, my lord, I submit, the complaint is regarding seepage of drainage water from my drain, the alleged seepage from my drain into my neighbor's compound, my lord. So, I submit, my lord, from whatever is available with me at the moment, it is more than apparent because all compliances that have been sought from me from time to time is in respect of that drain only. There is nothing else. Repair your neighbor's wall, there would be no question of that unless it was the neighbor's complaint that has activated the entire process. So it becomes very evident that it is a private dispute, a private complaint. And in that context, that was the reason I had submitted that 133 proceedings cannot be drawn up, and this is what the Supreme Court also says, my lord. Lordship, this 1995 judgment, para 3 may kindly be looked at, my lord.
Yes.
Para 3, my lord, slightly longish para. I request that Lordship kindly turns the page and allows me to read from the third line itself, my lord. The object and public purpose behind Section 133.
Yes.
The object and public purpose behind Section 133 is to prevent public nuisance that if the magistrate fails to take immediate recourse to Section 133, irreparable damage would be done to the public. The exercise of the power should be one of judicious discretion, objectively exercised on pragmatic consideration of the given facts and circumstances from evidence on record. The proceedings under Section 133 is not intended to settle private disputes or a substitute to settle civil disputes, though the proceedings under Section 133 is more in the nature of civil proceedings in a summary nature. I reiterate, my lord, the proceedings under 133 is not intended to settle private disputes. Similarly, my lord, para 5. Yes. Para 5, my lord, in TKSM so-and-so versus so-and-so, the Madras High Court held that the alleged nuisance would have been in existence. would have been in existence for a long period. The circumstances and the evidence in that case did not prove that an urgency existed warranting the taking of action under Section 133. No action can be taken under this section where the obstruction or nuisance has been in existence for a long period and the only remedy open to the aggrieved party was to move the civil court. It was also held that Section 133 is attracted only in cases of emergency and immediate danger to the health or physical comfort of the community, my lord. So from para 5, two things come out, my lord. One very obvious thing, that the nuisance has to be related to the community, my lord. It cannot be a person specific or a property specific allegation of nuisance, my lord. Secondly, my lord, the nuisance should have been in existence for a long period. It cannot be a nuisance that has emerged suddenly, my lord. My drain has been in existence since my property has existed there since last 50, 60, 70 years, my lord. So it is not something that has happened suddenly. That drain has always been there, my lord. But most importantly, what comes out through this judgment, my lord, is that a private dispute, my lord, cannot be adjudicated, cannot attract Section 133. Now, just one more judgment would be relevant, just to understand, my lord, what would the term community or the public mean in the context of Section 133, my lord. This 2005 judgment from Supreme Court, para 10 of this judgment, my lord. Now, para 10, firstly, my lord, it is regarding the order that was last passed, shutting down trade occupation. In that context, para 10, my lord, if lordship kindly turns the page again, there is a dotted line in the middle of the page, my lord. Just above the dotted line, although every person is bound. Just 3 lines above, 4 lines above the dotted line, my lord. Although every person is bound.
Just a moment.
Para 10 of this judgment, my lord.
Yes, para 10, of course. It's a longish.
Yes, my lord. So that's the reason I request, my lord, to kindly turn the page. There is a dotted line on the next page. It says page 42, just below the dotted line.
Okay.
Just above the dotted line, 3 lines above, it starts, although every person, my lord.
Yes.
Yes, ma'am. I'll read this part, my lord. Although every person is bound to so use his property that it may not work legal damage or harm to his neighbor, yet, on the other hand, no one has a right to interfere with the free and full enjoyment by such person of his property, except on clear and absolute proof that such use of it by him is producing such legal damage or harm. Therefore, a lawful and necessary trade ought not to be interfered with unless it is proved to be injurious to the health or physical comfort of the community. Proceedings under Section 133.
This speaks about a trade in operation.
Yes, my lord.
It doesn't speak about the per se the drain or
no. So that's the reason I'm highlighting this judgment is in respect of the order that was passed, the order to shut down my and my my tenants' businesses, my lord. So in that context, Supreme Court has very clearly stipulated that a lawful trade should not be lightly interfered with, unless it is shown that that conduct of that trade is causing harm to the community. In this case, there is no such allegation.
So there's no nexus between the trade in question or the
trade
and the drain.
Yes, my lord. There is nothing, and the learned magistrate has not taken the trouble of pointing out in what manner is the conduct of those businesses affecting the drain or the community's interests at large, my lord. Same, if I'm allowed to continue, my lord. Proceedings under Section 133 are not intended to settle private disputes between different members of the public. They are in fact intended to protect the public as a whole against inconvenience. I'll just skip to the last line, my lord. This is very relevant. In order to bring, my lord, in order to bring a trade or occupation within the lordship has...
Next page.
No, same page, my lord. third last line, my lord. In order to bring.
Yes.
In order to bring a trade or occupation within the operation of this section, it must be shown that the interference with public comfort was considerable and a large section of the public was affected injuriously. I'm stressing on this next line, my lord. The word community in clause B of section 133(1) cannot be taken to mean residents of a particular house. It means something wider, that is the public at large and the residents of an entire locality. So 133, my lord, even if there is some sort of nuisance, if the nuisance is a person-specific or a property-specific nuisance, 133 is not attractive. Community in subclause so-and-so of 133 cannot be taken to mean residents of a particular house. It means something wider, that is the public at large or the residents of an entire locality. And in the same tone, my lord, at para 11.
Yes.
In the same tone at para 11, my lord. The guns of section 133 go into action whenever there is public nuisance. The public power of the magistrate under the code is a public duty to the members of the public who are victims of the nuisance, and so he shall exercise it when the jurisdictional facts are present. All power is a trust that we are accountable for its exercise, that from the people and for the people all springs and all must exist. The conduct of the trade must be injurious in presenti to the health or physical comfort of the community. There must at any rate be an imminent danger to the health or the physical comfort of the community in the locality in which the trade or occupation is conducted. Unless there is such imminent danger to the health or physical comfort of that community, or the conduct of the trade and occupation is in fact injurious to the health or the physical comfort of that community, an order under section 133 cannot be passed. A co-joint reading of section 133 and 138 of the code discloses that it is the function of the magistrate to conduct an inquiry and to decide as to whether there was reliable evidence or not to come to the conclusion to act under section 133. So again, like the previous judgment, two things stare us in the face from this judgment, my lord. First, a trade or lawful trade or occupation cannot be interfered with unless the community is threatened. Secondly, my lord, community has been described, has been elaborated upon. Community, public cannot mean one person, one property. It has to be the entire locality as a whole, my lord. In this case, no such allegation is there. Even if there is an allegation against me from my neighbor, it is specified, it is restricted to his property, my lord. So in any event of the matter, 133 is not attracted. Power under 133 was mistakenly exercised by the learned magistrate in this case. He has compounded the illegality by passing an order without any basis, shutting down my and my tenants' businesses, etc. Point is, my lord, very simple point that I'll place before this honorable court. 133 cannot be invoked to settle a private dispute.
Your businesses are still shut?
No. Through intervention of this honorable court, there was a interim order passed. Now I'm functioning. And that is only because of the intervention of this honorable court, my lord. Just one last point which I'd like to highlight, and this flows out from the last line of which I had read. This judgment speaks of section 138 also. Section 138 also, my lord, plays a part in this case. If lordship kindly looks at section 138. Now, once I'm issued notice or an order is passed by the magistrate, if lordship looks at 138, procedure where he appears to show cause. Subclause 1, yes. If the person against whom an order under section 133 is made appears and show cause against the order, the magistrate shall take evidence in the matter as in a summons case. Number 2, if the magistrate is satisfied that the order either as originally made or subject to such modification as he considers necessary is reasonable and proper, the order shall be made absolute without modification, or as the case may be with such modification. If the magistrate is not so satisfied, no further proceeding shall be taken in the case. I focus on subclause 1, my lord. Subsection 1. If the person appears and files a show cause then the magistrate is required, he is duty bound to take evidence in the matter as in a summons case. In this present matter, my lord, Lordship may kindly look at page 33.
Yes.
Once proceedings were drawn up, orders were passed, etc., I filed a show cause on 29/9/2022.
Yes.
Once I had filed a show cause, 138 comes into play, my lord.
Yes.
And the magistrate was required to call for evidence as in a summons case. Clear mandate, clear requirement of 138. No such thing was done, my lord.
Yes.
So, my lord, I would humbly submit, in spite, notwithstanding the submissions made on the last date in this case, issue before this honorable court is very simple, my lord. Are the proceedings under 133 drawn up by the magistrate in Nongpo, are they sustainable, are they maintainable? In view of the well-settled law, they are not maintainable. In view of the circumstances of the case where there is a private dispute, private allegation, private complaint, 133 cannot be entertained, my lord. Cannot be attracted. Proceedings, my lord, I humbly submit, have to be cautioned. That's all.
I'm thankful to my friend for having read 138. Lordship will just come back to page 33.
Yes.
Let me start from where he left. Initially, when he started, I was a bit nervous, honestly. But everything has evaporated now. Lordship, page 33.
Yes.
Lordship will assume this as the show cause under 138. Lordship, can we assume this as show cause because that's his stand?
That's what he said.
Lordship, for the moment, if we assume that's a show cause, first thing is this: he has surrendered to 138. He willingly, voluntarily surrendered to 138. Now, if he has surrendered to 138, Lordship, he had two options. One was, admittedly, he says he has not received the copy of the complaint. So he doesn't know what is the complaint. Now, if he did not receive the copy of complaint, Lordship, when he invoked 138 to file a show cause, he should have mentioned it. He can't file effective show cause because there is no complaint copy. There is a stand before the High Court. I'm afraid that is not the stand on 29/9/2022. So, in other words, he was in the know of the show cause. That is a minor argument that I'm forwarding, Your Lordship, for the moment. But there are two important legal arguments here. One is that he submitted to 138 without getting the copy of the complaint. First thing is this: he has not overcome what was the complaint. Second thing, assume that he is not aware of what was the complaint. No, the second option would be what? The argument that he has forwarded at length relying on Supreme Court judgment. That whether there is any whisper in the show cause. Since he has invoked 138, the first legal argument would have been this: the magistrate has wrongly invoked 133. So he should and he ought to have challenged the jurisdiction per se under 138. Again, Lordship, allow me to just repeat because it's slightly a technical argument. He had two options before invoking 138, which is admitted stand. Either he should have come to High Court under 482 before 138, which he has not done. He has surrendered it. So that means he has complied. He accepts 133's jurisdiction. Law point. Second, on factual aspect, he should have brought that law point and asked the magistrate, kindly agitate this issue of 133 first because there is no material before me. As I submitted, Lordship, I had to repeat because he didn't have the complaint copy. Still he chose to surrender. In choosing to surrender, not approaching the Honorable High Court, but choosing to surrender, he has not raised the issue. The question would be, I won't raise the issue of acquiescence or waiver. On the issue of factual part of it, he surrendered. And if he is not mentioned in the entire 29/9/2022 that magistrate had wrongly invoked, the first legal issue would be, can he raise now? And especially, Lordship, again, this is a show cause. That means the proceeding under 133 has just started. I'm thankful to my friend that he read out 138. I will not repeat by reading again. It clearly says evidence has to be recorded. We are not going into the part of the order which has been stated. That could be a shaky decision, Lordship. I'll have to admit honestly, writing on the note rejected apparently looks wrong. That this court has to correct that, and I would agree with my friend on that part. But that is not the case here. The case here is 133 is not. Invoking 133 was wrong. Neither is taking the plea. And if you read this, Lordship, if you read this on merit, he has suggested what was the dream. Lordship will kindly, again I will not, again...
See, Mr. Khan,
Lordship. Lordship will kindly...
he has filed this, let's put it this way, if he has put it before the court that it is a show cause.
And he submits that it is a show cause.
He has submitted the show cause notice, show cause on 29/9/2022. So it is incumbent upon the magistrate to take the proceedings forward.
Absolutely correct. Lordship, I am to that.
Recording evidence.
Lordship,
has that been done?
Lordship will kindly appreciate that. That stage, that is exactly where we stand. Because the argument that he forwarded before 138 was a totally different argument. Now, what remains after 138 is this, all his other argument prior to 138, by his own submission, stands self-contradicted, defeated, or rather he has to choose whether he approbates the first part or the second part. According to me, Lordship, he cannot approbate and reprobate both the sides, pre-138 and post-138. If he stands by 138, then what has fallen from your Lordship is a very valid query.
Yes.
Whether 138 evidence has been recorded. Lordship, my respectful submission I submit to the court, that has not been done yet. Before that evidence and final order.
So would that vitiate the proceedings?
Lordship, it will not vitiate except Lordship will see kindly 29/9/2022 is the first show cause. And the next page, Lordship, page 35.
Yes.
Not only they give the first show cause, but they also given a further clarification.
Yes.
Lordship, kindly allow me to invite the court to page 37.
Yes.
Lordship will kindly go to in the matter of application for extension of time filed by the respondent. Not only there is two show cause, but this is very important, that also file an application in the proceedings for extension of time, which is 17 January 2023.
So this is with regard to the construction or rather rectification of the
absolutely Lordship,
of the subject matter.
Lordship, I am just into 138. Lordship, will kindly come to page 49. Lordship, in the matter of filing of completion report.
Yes.
And the relevant part will be, Lordship, page 50, the prayer, 5th April 2023.
Yes.
Lordship, let me just read the prayer.
Please.
In the premises, it is therefore prayed that this learned court may be pleased to resign the oral order of closure of all activities of tenants and respondents and grant 1 month time to the respondent to complete the work towards prevention of any seepage of water as pointed out by so and so, for which act of kindness the respondent shall ever pray. Lordship, will kindly notice this is the date is important, Lordship, 5th April 2023.
Yes.
Lordship, when this matter was moved in the motion stage, protection was given in spite of the fact there was an inquiry both by the court and both the counsels. The word used is to resign the oral order of closure. This is their prayer, Your Lordship. So when the word oral order of closure, this is an allegation against the executive magistrate that orally asked to close. Lordship, it is one thing to say before the Honorable High Court, oral order to close. Totally different thing to say what was the oral order. It is their case, there was an oral order, and it is the state's case, in the absence of what exactly oral order, in a sworn affidavit, the court will not be in a position to know what was passed.
The oral order apparently is directed towards the police.
For closure.
Yes, ma'am.
Closure. Lordship, it was their case before the Honorable High Court in this matter, in the stage of motion, that there was an oral order passed. So I'm making a distinction, Your Lordship. We can't deny it because something was written on the note rejected petition. That's an admitted fact. We can't deny it could be a case of an oral order. But we have to know at least it was not given to them in written. At least a statement should have been made in the petition on oath. This was the order. Other than the use of the word oral, there was nothing mentioned. So court find it very difficult to even pass prima facie an interim order, except that if there is such an order or the noting was there, so they should be getting a protection. Even now, as on date, when we are doing the hearing, Your Lordship, they have not come forward, neither they have filed a supplementary affidavit or bringing on record what was the oral order passed. Now, in the absence of that very vital exact words, not in writing and not in order sheet, not duly signed, but what was the order, that part was missing. Even now, it is missing. So their prayer was, based on that oral order, everything was for that they have put in.
But that oral order was brought on record in this petition, isn't it?
No, Lordship. No.
Para 16.
Lordship,
this is on affidavit.
Lordship will just come to para 16. Lordship, that is what my submission, Lordship. That on the evening of so-and-so, the respondent inspected the site and without giving any reason whatsoever, passed a verbal direction that all business activities on the land of the petitioner should immediately be stopped indefinitely. Respondent number 3 directed the police authorities present on the site to ensure strict compliance with the direction. It is humbly submitted such that it is wholly without jurisdiction and legal sanction. They said the word uses verbal direction. Lordship, I am not justifying this order. So far this is concerned, Your Lordship, can I make a candid submission?
No, we are looking to the veracity of it.
Lordship. So veracity of what was the oral order, except saying that he was asked the direction to pass. That what was the direction exactly per se, that is not brought into the record. We didn't have the position, then neither the state could have been in a position to justify. In spite of the fact, Your Lordship, I had made a submission that the executive magistrate was also made as a person named respondent. State can't defend, Lordship, if you say somebody is making oral order, except it was a certified copy, then we get it out. However, Lordship, that is not so material. What is material, Lordship, is that since they could not produce exactly what was the oral order, for a moment I am not justifying that such order can be passed or not. Absolutely not. That part of the oral order, that part of the writing in the note, that is per se illegal. But now, Your Lordship, coming back to 138, they have followed the procedure, filed a show cause, they have never challenged 133, neither they have whispered in the petition that it has no jurisdiction. Rather, not only have they surrendered or complied with 138, they have given elaborate explanation. Now, having given an explanation, having not raised the issue of 133, my first submission, Lordship, would be whether can they raise the issue at this stage. Secondly, 138 is in the stage of progress. What is fallen from Your Lordship, I'll just reply to that query. Is the evidence has to be recorded. And rightly my friend read out 138. After recording evidence, it can modify its order. It can resign its order. If it's completed, it can close. If it's a private dispute, as he rightly said, in case could be, which doesn't touch this, then it can, Lordship will kindly appreciate this is part 3 of the CRPC. Part 3, Lordship, doesn't start at 133 and ends at 138. Lordship may have done, I'm aware of it, Lordship may have done hundreds of cases. After 138, it ends at 145. So it comes within the same chapter, part 3. Just for a moment, Your Lordship, I'll just take to the heading of the chapter. Lordship, Chapter 9, sorry, apology, Lordship, I was mentioning 3. Chapter 9 is maintenance of public order and tranquility. Lordship, we'll just come to the, it starts with section 139.
$139.
129, Lordship. CRPC 129.
This is yes,
chapter 10, Lordship.
Chapter 10.
Maintenance of public order and tranquility. A is unlawful assembly, Your Lordship. B starts with public nuisance. And Your Lordship will come to C. Urgent cases of nuisance or apprehended danger. And Your Lordship will come to D. Dispute as to immovable property. 145. So under chapter 10, Your Lordship, under chapter 10, the power is there. As I said, Your Lordship, 133, 144, 145, this stage, Your Lordship, this stage will naturally arise after completion of 138 and then recording of the evidence. That has not yet happened. And again, to reiterate, Your Lordship, that oral closure and noting, that court has to interfere on that. And remand back the matter on that oral closure and that part, and remand back to the matter after show cause to follow the procedure under 138. So I will just conclude my argument, Your Lordship, in case if any query does not come from the court, that this is not the case of 133 invocation, because they themselves were not invoked. And this was, for the sake of argument, Your Lordship, 133, for the sake of argument, I'm not submitting to it. The same executive magistrate, after recording evidence, can shift it to 145. But he finds the drainage.
You see, what you mean to say is that the petitioner herein has, on the basis of an order passed under 133,
Lordship,
has voluntarily, joined proceedings.
Lordship, yes, on facts. No, not question the jurisdiction. And Lordship, not question the jurisdiction. And finally, in the last, he has asked for 1 month's time to complete the nuisance, whatever nuisance existed. And Your Lordship, just for a moment before I close, Your Lordship, I take a page 23 of the order, the petition. 8/12/2022. The petition.
Yes.
Lordship, prima facie, at least what is before this order of court, Your Lordship? The order of a court. If you read this, Your Lordship, I'll just go to para 1. Whereas it has been made to appear to me that you, the caretaker of so-and-so, has failed to construct a proper drainage channel and also failed to take necessary action in preventing the flow of drainage water into the property of so-and-so. Whereas you have failed to maintain the hygiene and sanitation which poses a serious threat to public health. Whereas I am satisfied that the gravity, severity of the situation and the same amounts to serious public nuisance which poses a threat to public health. Prima facie, Your Lordship. Serious public nuisance which poses a threat to public health. Therefore, I do hereby direct you within 30 days from the date of this order to remove, clear all nuisance and adopt strict hygiene and sanitary measures thereupon and to submit an action taken so and so. Lordship, I am into two aspects of it. The issue here is drainage. Second is this serious public nuisance whereby it poses threat to public health. Now, this is a prima facie observation on the basis of complaint. Admittedly, my friend doesn't have a copy of the complaint. Now, this prima facie satisfaction can be dispelled by better fact emerging only on completion of show cause, on being led evidence. So that stage has not come, Your Lordship, and the matter is still stuck up. So prima facie, Your Lordship, we even go by the order. The issue of public nuisance affecting public health is well written in the order. That stage could either turn in his favor or in favor of the private respondent only on completion of 138. So, Lordship, I just want to rest my case that prima facie there was a mechanism for invoking under 133 and they have not surrendered to the jurisdiction. 138 is yet to be complete. Only my concession, legal concession, would be the writing of the oral and rejecting the note. That seems to be not as per proceedings. Oblige, Lordship.
Lordship, this 3 very quick responses, my lord. 3 points have been raised. 3 very quick responses.
Yes.
First, my lord, the submission of the respondent that I have submitted myself to the jurisdiction under 133, read with 138, my lord. Lordship, two responses on this issue. First, my lord, these proceedings, Lordship will have to kindly appreciate, these are not really proceedings in a court of law as we know it. These are proceedings more of an administrative nature, conducted in a, at best, a quasi-judicial setting, my lord. Lawyers are not present. It is only lay persons facing the might of the state in a closed room, my lord. So the orders which are passed from time to time in such proceedings under 133, 145, any chapter 10 proceeding of the CRPC have to be read in that background, my lord. Keeping that in mind, a show cause was filed. At one point, a show cause was filed. The objection has been raised that in that show cause, I did not take the issue of jurisdiction. I did not say that you are not entitled to draw up 133 proceedings. Show cause was filed by a layperson in a proceeding which was not a judicial proceeding, strictly speaking. Number one. Number two, an issue of jurisdiction or a challenge to jurisdiction, and this is established law, my lord. A challenge to jurisdiction can be raised at any point, even in collateral proceedings, even at the stage of appeal, my lord. So it is not like I have participated in a particular proceeding and therefore I have waived off my right to raise the issue of jurisdiction for all time to come. There are n number of judgments on this issue. I have to confess my surprise at the senior counsel agitating this point, because jurisdiction, absence of jurisdiction is a point that can be raised at any time, like I have done before this honorable court through this petition, my lord. It can be raised in collateral proceedings at the stage of appeal at any point, my lord. I will be obliged if my lord gives me an opportunity to submit necessary authorities in that respect by tomorrow, my lord. There are n number of authorities. I am not equipped.
That is also easy. I think it's well settled.
It is very well settled. So jurisdiction, the fact that I did not raise the issue of jurisdiction at one point in the past, it cannot be held against me, my lord. I can raise the issue of jurisdiction if this matter reaches the Supreme Court. Even at that stage, I could have for the first time raised the issue of jurisdiction, my lord. There is no bar under law in that respect, my lord. So to say that...
But what is to be looked into is your conduct.
Yes, ma'am. I was just coming to the fact that I have filed a show cause and apparently much is being made out of that show cause, and I have submitted myself to 138 through that show cause, my lord. It's not like that, my lord. The date of the show cause is important. Date of the show cause is 29th September 2022. Lordship may kindly take a note of this, 29th September 2022. Yeah. Now, this show cause was in respect of...
That is page
33 is my show cause. That is 29th September 2022.
Yes.
Now this show cause was filed after I received the notice at page 21. Page 21 notice, if your lordship kindly sees. Page 21 is a notice dated 19th September. And I stress on this, it is not an order, it is a notice.
Yes.
A notice saying that, informing me that there will be a spot inspection on so and so date. So I received a notice on 19th September. 29th September, I filed a representation. I will call it that. After I filed the representation, after some sort of spot inspection, the first order was passed. Order under 133, that is at page 22. Again, the date is important.
Yes.
Date of this order is 3rd October.
Yes.
That means after my representation.
Yes.
Why I am highlighting all this is because 138 respondent has thanked me for reading or pointing out 138, but 138 has to be read slowly, my lord. If lordship looks at what is the exact stipulation of 138,
yes,
138 subsection 1. One, 138 subsection 1. If the person against whom an order under section 133 is made appears and show causes against the order, the magistrate shall take evidence in the manner as in a summons case. So for a representation or any piece of paper to be considered as a show cause under 138, strictly speaking, first there has to be an order. Person receives the order and show causes against the order, then the magistrate will have to call for evidence and adduce evidence as in a summons case. So this representation of mine was not after an order, it was before an order. So that was why I had highlighted the dates. My representation is 29th September. Order comes on 3rd October. 138 requires first order, then representation on show cause, my lord. So why I had highlighted this representation was just to bring to the attention of this honorable court that there was a representation from my side, even before any orders had been passed. Based on the powers under section 138, based on the stipulation under 138, it was incumbent on the part of the magistrate to treat that the representation submitted before any order as a show cause under 138 and then maybe call for evidence. So nothing much can be made out of this representation in view of the fact that it was filed before any order had been passed itself. So I have not submitted myself or bought into the fact that 138 proceedings have been drawn up, and I am happily participating in those proceedings. Nothing like that, my lord. Nothing like that. And the fact remains that absence of jurisdiction is a point that can be raised at any point in time, my lord. My last response. A faint submission was made that the exact contents of the verbal order, that's not very clear, my lord. I had pointed out para 16 of my petition. Para 16 on affidavit is very clear. I have said what was that verbal order to shut down the businesses.
Yes.
But in spite of this being pointed out, the point was still pressed that we do not know exactly what was the order. We do not know whether the order actually said shut down your business. In response, my lord, I draw lordship's attention to the status report filed by the magistrate.
That is a page?
That has come on record on the last date from the respondent. It's a status report dated 21st April, my lord.
Okay.
It's a one-page document.
Yes.
Now, my lord, the last line of this order.
Yes.
Last line of this order, as per Honorable High Court order dated 6/4/2023, no further action has been taken. So on the date he prepares the status report, he has read the first order passed by this Honorable High Court. If lordship looks at the first order passed by this Honorable High Court,
yes.
Para 5 of this order, my lord.
Page order dated?
The first order, my lord, 6/4/2023.
Yes.
Para 5 of this order, my lord.
Yes.
Para 5 of Honorable Court's order. Para 5, my lord, records my submission. That the learned counsel submits that pursuant to the said spot inspection, respondent number 3 via a verbal order had directed the tenants located in the petitioner's land to stop their activities. He further submits that though an application was filed before the respondent number 3 praying for recall of the said verbal order, the same was rejected. He also submits, it goes on, my lord. So I have my submission that there was a verbal order ordering for shutting down my business, my tenants' businesses, that has been recorded by the Honorable Court, my lord. Magistrate reads this order. If my submission was incorrect, magistrate would have said so, my lord. The fact that he has not disputed by contention or the observation also, subsequent observation of this Honorable Court, and not put in something to the effect that there was no such verbal order to shut down businesses, establishes beyond any doubt that there was, number one, there was a verbal order. Number two, there was a verbal order to shut down businesses, which was way beyond any jurisdiction, my lord. My last request to this Honorable Court, my lord, is to kindly observe that in the first round of my submissions today, I raised just one point. That is, private dispute cannot be adjudicated under 133. Submissions have been advanced by respondent, but not a single submission against that one point. Many submissions have been advanced. I have submitted myself to the jurisdiction, I have conceded to the jurisdiction, etc., veracity of the verbal order, etc. But this is my only point before this Honorable Court. It is a private dispute. Materials establish it is a private dispute. There is no response that is advanced against that. So if it is a private dispute, law is very clear, my lord.
But if there's an element of, the public nuisance or otherwise,
yes,
that has to be looked into.
Yes, my lord. But yes, my lord. In the handicap that we face, my lord, is the fact is the problem that the complaint, my lord, is not before this Honorable Court. But even in the absence,
is it mandatory for you to receive a copy of the complaint?
Lordship, natural justice would demand if there is an allegation or complaint against me, I should get a copy of that, my lord. So in the absence of the complaint, and because of that I have not been able to attach it, but leaving that aside for a moment, I would request this Honorable Court to conclude that even on the basis of whatever material is available, it is very clear that there was a complaint against me by my neighbor. I doubt a service station, a petrol pump would be of some sort of public-spirited, would be a public-spirited person to agitate some community grievance, my lord. He runs a public petrol pump, my lord. That is, that establishes that he has no public-spirited endeavor behind his actions. His complaint was limited to the fact that the allegation was that my water is seeping into his compound, my lord. The actions or the orders that have been subsequently passed by the magistrate all point towards that, the fact that there was seepage of water into my neighbor's compound. My compliance, whatever I could manage till date, was also in that respect, as I had pointed out, and I put on affidavit also, that I have done what I could. I have cemented the drain, I have repaired my neighbor's wall. All these facts taken cumulatively, my lord, show that the nuisance in this case, if there is a nuisance, is a nuisance directed against, in respect of one private person, my lord. There is no community interest involved. There is no public element involved, my lord. That being the case, fact remains that Honorable Court will have to intervene. There is no question of sending the matter back. Matter has progressed a long way, my lord. It's been going on for almost 1 year without any authority, without any jurisdiction. Honorable Court, I submit, will have to intervene at this stage and declare these proceedings as not maintainable in view of the law that has been well settled. That's all.
Allow me just leave the court. Lordship, just one point to clarify. Just one law point. Yes, the issue is jurisdiction in Lordship. Just a law point. My friend said there are 100 judgments on that issue. He's trying to be slightly guarded. They are not 100, there are more than 1,000 judgments. But the basic principles of jurisdiction in Lordship is inherent, territorial, or pecuniary. Our case, Your Lordship, he's trying to mislead my keeping silent into something which I didn't say. If I may clarify, Your Lordship, it's not the case of pecuniary, it's not the case of territorial, and it's also not the case of inherent. If I may clarify, Your Lordship, when I'm objecting, it's not inherent. What I'm submitting, Your Lordship, is this: if it's the issue of fact, whether the judgment, both the judgment, I don't understand why he was trying to mislead the court. Both the judgments are about building. On facts, those judgments are not applicable. That would have taken a lot of time for me to clarify. But Your Lordship, I thought Lordship had raised that query. It's about building. There's not even a judgment about drainage. The issue here was drainage, and whether drainage and public health on issue of fact, whether that would constitute inherent lack of jurisdiction. Lordship, am I putting the question properly? Whether it will constitute, if those facts are not present, whether it will constitute inherent lack of jurisdiction or jurisdiction exercised by the magistrate exceeding its power. Exceeding its power would be when there was no facts present. Per se, if the magistrate didn't have the power even to entertain the complaint. So, Lordship, here the case, here, Lordship, just allow me to
as far as the concept of jurisdiction is concerned, you see,
Lordship, there has to be
aware of the contours of
Lordship, for example, I'll just give an example. What everybody, normally lawyer comes to the court, they start using expletives, no jurisdiction, without bringing the context. We understand if district council doesn't have a jurisdiction to try two tribals. Sorry, it has a jurisdiction, but then a normal court tries here. Anybody can come, invokes para-4 and says, no, it doesn't have inherent jurisdiction, as per constitution, as per district council law. There can't be any reply to that. On that, there are hundreds of judgments. So for this is concerned, Your Lordship, whether court exercise power based on the facts available or not. If there was no facts, it would have exceeded its jurisdiction. And if it would have exceeded Your Lordship, then it would have changed the gear from 133 to 144, 145. Because everything comes under chapter 10. So my submission, Your Lordship, law is this is totally a wrong submission most councils make, blurting out no inherent lack of jurisdiction. This is not the case here, Lordship.
What you can do,
if there is a judgment,
if that's the case, then you produce authorities.
Lordship, Your Lordship, my specific authority on that, there is a distinction between inherent lack of jurisdiction and wrong exercise of power or non-evaluative fact. My reply, Your Lordship, would be the second limb of the argument that it was non-application of jurisdiction or exceeded jurisdiction on non-evaluative of fact. They should have raised it in the show cause. They have not done it, Your Lordship, and rather they have surrendered to the jurisdiction.
So you do one thing, Mr. Khan, as well as Mr. Jindal.
Yes, ma'am.
On this specific point, with regard to the facts and circumstances of this case.
Yes, ma'am.
You just give me a list of those authorities.
Obliged, because
as far as jurisdiction is concerned,
absolutely.
So, Lordship, we have to make a distinction between wrong application.
There would be,
Lordship, if I may submit,
there would be pronouncement on this issue.
Some could be there, Lordship, but then this is a settled principle. Lordship, normally,
since you have tried to distinguish, you see, the
inherent lack of jurisdiction and
vis-a-vis the jurisdiction as far as this case is concerned.
That, Lordship, in the last date I had argued at length. Lordship, once me I can argue next day how under 133 it's applicable. I've argued at length, and then we'll end up on it.
Lordship, just give a list of the
at least one judgment we can produce. Non-application of jurisdiction and inherent lack of jurisdiction. We are not into pecuniary and territorial.
Tomorrow?
Very well.
Okay. We'll try.
But under counsel for the parties, the hearing being concluded. However, the parties have submitted that they may be allowed to present certain authorities, particularly with regard to the issue of jurisdiction. As far as the facts and circumstances of this instant case is concerned. So you're talking about hundreds and thousands, we will not need that.
Not required.
Confine yourself to
principles of law.
Confine yourself
with Lordship's permission, I'll produce 3. That's all.
No, that doesn't matter. You can produce 3, 4, 5, it doesn't matter.
3 should be more than enough. Obliged.
For tomorrow.
Obliged.
This is matter tomorrow for the hearing.
Item number 5.
So, where were we?
I'm sorry that on the last occasion I was not present.
Yes.
Because of my health, I had to rush back for my medication.
You should have at least informed inform the court through some of your colleagues.
Yes, my lord. So I tender my unconditional apology for that inconvenience caused, my lord. Today also, in fact, I am not fully recovered, but still I'll try to assist, my lord.
So we'll take it up in the second half. I'm not sure. So, any other matter? We'll take up this matter in the second half.
Yes,
Mr. Chaudhary, you're ready. Can you
Yes,
can you wait till second half, or you're too weak to stand?
No, I'll definitely finish. It's been 2014 matters, my lord.
That's what I said. It's old matter.
It is because of this asthmatic tendency that I've been taking medication, and from time to time it relapses. So
That is true.
that is what is causing me all the harm.
You think about it. You see, your health is more important than anything else.
No, I can.
My lord,
Yes, Mr. Rindu.
item number 13 is there. It would require some time, because this is regarding the question of limitation, applicability of the Limitation Act in the District Council courts. Because this, the additional judge, District Council Court, has held that in spite of the Shela judgment, that the Limitation Act is not applicable between tribals. So in fact, Justice Thank You could not take up this matter because he was the conducting counsel for one of the clients.
This is a second appeal.
Second appeal. The issue is important because the another law point which was framed by the court is whether the judgment of the Shela judgment is per incurium in view of the fact that the 1950 rules, Khasi Shem Se, I think 34, expressly it provides that the Limitation Act will not be applicable to tribals. This aspect of the matter was never taken up by the full bench.
Okay.
So it becomes a judgment per incurium. Of course, this is for academic purpose.
Yes, because the issue of limitation has been decided by.
Yes, by the full court has said that even in tribal areas. But then the statute is there. So unlike Article 141, where the judgment of the Supreme Court is binding, is applicable to the entire country, now there is no such provision. So what happens is that between a judgment and a statute, what would prevail? Whether the statute will prevail or the judgment of the...
Obviously, it would be a statute. Anyway, we'll look into it.
So it requires a little bit of...
Because in the judgment also, Your Lordship, only the notification has been quashed, not the rule constituted under the 6th schedule. It has not been quashed. So that one is still intact.
Fine. So when do you want it?
Let it be next week. In the meantime, I'll prepare a compilation also. I think that will help.
Let Your Lordship.
With all the judgments.
Because it is mostly only on points of law.
Points of law, Your Lordship.
No, another aspect was that the additional judge of the District Council Court has relied on on the sameship rules of 1950, which is again not applicable in the District Council courts. That is where she went wrong.
Okay.
Because under the administration of justice rules in the Khasi Hills, there is no such provision that the Limitation Act will not be applicable. But in the 1950 Khasi sameship rules, that particular section is there.
53, even 1937 also is there, Your Lordship.
53 is there. Fine. 13 on pre-meet parties. This is matter to 1 week.
One more matter is there, Your Lordship, that the jurisdiction of the additional deputy commissioner and all. That Garo Hills case. Item number 8.
Yes.
It's fixed.
So what do we do with this?
I brought some notification and all. Lordship.
You are prepared to take up this matter?
Yes, Your Lordship, I can.
Yes, Your Lordship.
So we'll take it up in the second half.
Please, Your Lordship, if the notifications
Very
will be
well.
handed over, I can prepare it on
Yeah, I have books I have, I can give you.
the list of notifications or the books which my friends.
Notification you have.
Have you, I mean, prepared a list of books?
No, Your
Or
Lordship, only
authorities that you are-
1937 I am relying, 1937. For that I have brought the book, as well as this Assam Autonomous District Council rule also I have, Act 1960. So that I have book, and for that I will provide him, Your Lordship, that head of station one.
So?
Lordship, if can be given the books, I can prepare it in the
I
meantime.
can give book now if you want to prepare.
The list of books which my friend be relying on.
You give him.
Only this book is there, Your Lordship.
Whatever the case may be. So,
I can give it.
so we'll take it up in the second half then, Mr. Karuna.
My lord,
deeply obliged.
Item 14, though it appears in the hearing list, but both the parties were directed to file their written argument. We have exchanged our written argument today.
Oh, this one.
So if the matter can come up next.
Is there any more hearing to be?
It was finally heard. A written argument is there. Necessary order can be passed.
So judgment will be reserved then.
That's it.
I think 14. No? Parties have filed their respective written argument. Matter is accordingly reserved for judgment.
Deeply obliged.
Yes, Mr. Jha, anything else?
Item number 6, my lord. That is with regards to that grant of ACP and non-ACP, my lord. So, my lord, on the last occasion has directed to file a written argument, my lord.
Yes.
Lordship, some more time may be given, Lordship, to file.
Have you filed yours?
No, I will require my lord sometime because it's calculation of the numericals are there, my lord. Since that calculations.
Yeah, that's what. Have you, I mean,
We will within a week, ma'am.
on pre-made by the parties who have submitted that the written argument could not be filed today. The matter is adjourned. This is after 1 week, 2 weeks.
2 weeks.
2 weeks.
Lordship.
call item number 5.
Where are the others?
May I start, Your Lordship?
Yes, you can start.
Your Lordship, here in the background of this case, Your Lordship, is little bit if highlight, then it will be better. So here petitioner, the Imam M.D. Abul Alam Abdullah, was appointed on by the order dated 21/9/1994.
That is annexure.
Is this in my compilation in page 170, you listen.
Compilation. Where is it?
This is right.
Page?
Page 170, compilation. So I am going to compilation because I have given the compilation for all, so many affidavits and petition. I have given copy. I have given copy to you. This one compilation. Compilation for short submission.
Anyway, I'll rely on my affidavit since my no problem. I'll rely on my affidavit on it.
Page?
Page 170. 170.
Yes.
Dated 21st September 1994. In person, the resolution number 1 adopted by the MC in the meeting dated 7/8/1994 and as approved by the Inspector School, West Garo Hills, Tura, by memo number dated 29/94, Sri Imam M.D. Abu Alum Abdullah, BSc, Rural, is hereby appointed as science teacher, Rural, with effect from the date of his joining in this school at a monthly salary to be given, subject to the availability of the fund and grants. The appointment is purely temporary and is subject to terminate anytime without any reason. He should join his duty within 15 days from the date of receipt of this order, failing which the appointment will be stand automatic cancelled. So after this, you will see he has joined in his duty. He was continuing this his duties and as a teacher. So
Till which year?
So till date.
No, 1995 he has already been terminated. That is my affidavit.
Well, let him, Mr. Sengupta.
Yes, my lord.
Let him submit. You will
My
get your.
affidavit I have categorically stated, my lord, that his services was terminated on 15/3/1995, and there is no rebuttal from his side. I have not seen.
Anyway, like I said,
So because admitting whatever he says, and if it is not rebuted, my lord, it might give a wrong impression of the petitioner's legal position, my lord.
Your Lordship, if he give that, otherwise he let him argue, Your Lordship, then I will give the answer only.
No, we have already finished the argument. We have given our written submission, and thereafter he is again opening up the case. That is where I am objecting, my lord. Why then we have to go through the entire process of written argument and synopsis?
What was, you have already given your.
Your Lordship, I have argued the matters. Again, say this synopsis to be given. I have given the synopsis whatsoever thereof. And after giving these ones, court was asking some points. Even from the clarification of my Lucas 20, then I have given. Again, court says that to give some light of it, so I am doing to it. So if Your Lordship, in this way it is come out, I don't know what has happened there. Now,
let him refresh whatever has been submitted.
Just only, I am just refreshing these memories, whatsoever this case thereof, because Managing Committee even saying this, it is not even maintainable, this petition. So for what purpose I came before this court? What for termination I came over here, Your Lordship? I am not coming for the termination. I'm not saying I've been terminated or not terminated. I'm not on this. I am asking my salary, whatever government is approved to in my name, and give to my this salary. How this government is saying I have been terminated or not, and their report, their things, they are misleading, and the person who has given the even affidavit, Your Lordship, he has filed the affidavit, it is the false affidavit. He should be even punished for this.
Merely on the statement of the writ petitioner.
Your Lordship, I will be proving this one, why it is, this, Your Lordship, Your Lordship, I will be proving it, Your Lordship.
Bring disputed questions of fact.
Not disputed question of fact, Your Lordship.
Whatever he is saying is the gospel, and whatever other respondents will be telling is the false. How
Anyway,
is
so
that?
Your Lordship, I'll be
we'll look
proving,
into the matter.
Your Lordship, I'll be proving the matters out of the documents whatsoever before this honorable court. So here it should say after that, they have shown me terminated in 19/4/2002. Officially, they have shown me this I have been terminated. I came before this court. I got the stay, and court is given to continue. Then after this, in between, respondent number 10, respondent 12 also has come up for this her termination in the said school, and then in this case, when it is disposed of, it is disposed of in the common judgment. Then after the state has filed the writ appeal, wherein in writ appeal, the specific stand is taken by the government. I am the science teacher in the said school.
Ad hoc science teacher.
So, Your Lordship, after that, for 7, then when I am not getting my salary, then I file the contempt. In contempt, then after this, they say this it is being given, and it was here and there. Thereafter, Your Lordship, when I was not getting my arrear of salary, then I approached before this court. Then court has passed the order as per entitlement to pay. Then, Your Lordship, what's happened? It was not paid, so I filed the contempt. In contempt, the managing committee came here, and this given the statement. I am entitled for 30,500. This is my entitlement, and given the check in the registry, I didn't accept it. Then I challenge this, why it is not acceptable by me. This is the case here, Your Lordship, for my arrear of salary.
Okay.
So here they have said it is terminated and others. I am having the record. Even that point of time when they have taken in 1995, even I terminated, then also it was their managing committee was not there, and it is in the American population, it is there, Your Lordship. And here, if it is in the 1995, Your Lordship, I have terminated. And how they can terminate me again in 19/4/2002? One person cannot be terminated twice for one appointment. This is my vision. If they are saying this, I have been terminated. Another aspect of the matter, Your Lordship.
Yes.
What is the cause of termination to me? So given if in 1995 they have terminated, this is given the cause to me, and appointed other this teacher even to in the my said post. There was likely to be some hesitations by this because I am the outsider. So is there anything in the government appointment, Your Lordship, if the outsider, not from the state of Meghalaya, and they have selected, they will be appointed, then they will terminate up due to this? Is there any rule for the government that this government to prove? And had it been so, then when they filed this writ appeal against the order of the single judge, they should come forward. That point of time they are saying this, I was a teacher, and not only this, Your Lordship, even in the matter, government has several times make the inquiry, and all this they are given this, I am the existence teacher. So whether this official who inspect and then who make the inquiry, they are not correct. So these are the all aspect of the matters, Your Lordship. If you and all these matters I have given in my synopsis, Your Lordship, in this category, all this synopsis, all this letter I have given because I have given compilation. So
the case is of 2015, my lord, and in my affidavit, my lord, page 10, we stated that the writ petitioner has received salary from DSCO till 28/2/2015. Till the filing of this case, my lord.
Anyway, let him finish. Yeah, Mr. Let him finish. So your case is for
only for the purpose of arrears of salary.
Arrears of salary from which period to which period?
I have given my statement, Your Lordship, here.
Where?
I have given.
Where is the statement?
In the writ petition. In writ petition, I have given, Your Lordship.
Page. Paragraph 12.
Paragraph 12.
So this is the total amount you have
Yes,
claimed.
Your Lordship.
4 lakhs.
4,77,125.
Arrears salary.
And the whatsoever government sanction letter, you will see all I mentioned here. And it was in my name. And all sanction letter I have given.
But you have not received.
I have not received, Your Lordship. And in the sanction letter, it is there, the name of the teacher who is mentioned, given to the same teacher only. And these are the notifications also I have given enclosed here, Your Lordship. So this is my case, Your Lordship. I am not coming for this whether terminated or not, one whatsoever thereof, Your Lordship. Already High Court order is there, then division bench order is there. So I am not coming on this because of it, Your Lordship, already if it is there and court has entered in this matter, then even when this court is asking me for the Lucan study, Your Lordship, I have given page 170 because this is the appointment of mine. So I was appointed legally, and if it is even terminated, then I should be given show cause. Nowhere to show cause, Your Lordship. I should be given the opportunity when the government is appointed to me. Proper procedure. Though they have taken the illegal actions in 2002, and immediately I approached before this court.
Okay.
And court has protected me. So subsequently, Your Lordship, when they are not making payment, I make this miscellaneous application here before this honorable court, and after this on directions only I got my salary, current salary, and now I am getting my current salary. I am not having any current salary due to this. That I am having any objection about it. I am not having it. So here
Are you still in service now?
Yes, Your Lordship.
You're still in service. Okay.
So here, Your Lordship, this is the paragraph 12 I have given, and all the copy I have given. What's the government issued the order? So if it is saying that it is a disputed fact, Your Lordship, I don't know how it will be. When the government has passed the order and given the money to this managing committee, how will it dispute the fact? And it is in my name. Only this must my clear, Your Lordship. So even I don't need even to open whole matters, Your Lordship, to go A to Z. Because I am not coming for the termination and whatsoever any other appointment. Even the private respondent who are there in this case, join in my case. I was not making the party because I am not having any grievance against her. If he is having the salary and others, I am not having any problem at all. I am not asking anything. Just it will be this some matters will be placement to me and others. I am not on this also. I am not having any grievance with the private respondent. So you will see when I will be saying this matters maybe I would be in that place and other has been appointed. Then that matter must come up. But here in this case, you will see in this case. The respondent of 12, who is the private respondent here, you will say, I am not having any grievance against her. I am not having any grievance. Because managing committee appointed and they will be paying, and then whatsoever even current salary she is getting separately, it is a different issue. I am asking whenever I have served, sanction is in my name, I should get this salary. Even in between, you will see some order whether they are not giving me the salary, and then inspectors given to me, and then in their managing committee affidavit I was not there. That I have given all the details in compilation. All the matters I have brought together because I have filed this affidavit, then managing committee filed affidavit, respondent 12 has filed the affidavit, even state has filed the affidavit. Again, I have given the rejoinder. Again, some reply has come up. Clarification has come up. So many matters is there. So instead of going all these matters, Your Lordship, I have given the compilation serialized this one, making this. Then also it become, Your Lordship, this serially also it is come about when whole matter says I discuss, Your Lordship, it has come about 13 pages.
Okay.
And I given all the annexure and I have written here whatsoever matter there, everything clarified in this matter. So when I have given all this clarification, in whole matters come up, even this termination of this, everything I have mentioned here, why it is not correct.
Okay.
Even here you receive in this matter of termination, she is saying, you receive in my compilation page 8.
Page 8.
Page 8 in my compilation, you receive. In compilation. Serial number 8. This portion of this compilation, this annexes.
No, this is your submission.
This is not after submission. If after 13, then compilation others are given, because in page number compilation I have given. So in this page number 8.
Just a moment. How many submission?
Here you see this compilation I have given, and this is the page number given for compilation. This compilation is 13 page. It's about 13 page.
Just a moment.
2 times give it, 2 times. তুমি রিসিভ করবে না, এই কোটা এসে আমি দেবো, এই সমস্ত করবো না।
This is you file on 29/3/2022.
I didn't mention the date here. May I just see you, Lordship?
I don't know. See, so many things are here. Completion.
So many affidavits, Lordship. So that's why it
No,
may.
we are talking about this file of written from the written submission, isn't it?
This compilation for short submission.
Yes. Short submission filed by petitioner.
Yes, Your Lordship.
So this is the table you have drawn up.
This is the table first of all I have drawn up, and number is given, then page number is subsequently.
Page number of the compilation is 1 to 4, then 5, then 6, 7.
Yeah, then 8.
8.
Then I am referring the 8. Have you got it, Your Lordship?
The first page.
Yes. This is the page, Your Lordship.
So just read out.
Statement released. This is the district school education officer, who is Garhustura. It is true. And written by this district science supervisor.
Not here.
Number 8.
Yes.
The statement related to this with the spot inquiry reported conducted by me on 24/19 as per office letter dated SWC such and such 16/4/1999. Referring to the above, I have the honor to give my statement as follows. As instructed by the then Inspector School JPK Marag, I have conducted the spot inquiry on 24/19 related to the post of science teacher of the Holy Gun School, secondary school. After I have conducted the spot inquiry, I have submitted handwritten report to the then Inspector School, and I did not keep any copy with me, due to the reason that as an RTI application submitted to the office with which asks for the copy of the report, but I could not have any copy with me or in the office since it has been quite long time, for 20 years ago. I hereby submit my statement as far as I can remember and recollect now regarding the spot inquiry conducted by me related to the post of the science teacher in Horizons Secondary School. My findings are as follows. Sri Imam M.D. Abul Abdullah was present in the school as science teacher as per the subject of teaching allotted to him in the school and as per attendance register. The inquiry was primarily conducted as he had been served with the termination letter by the then Secretary of MC of the school, but it was proved null and void as the terms of the Secretary of the MC after verification from the MC register was found to be expired. So you will see the person who has conducted inquiry at that point of time, and then subsequently he is given this report. He is saying it is given at 12 April 2019. This out of this RTI it is given, and then he is given that part of he is given the handwriting report, and it is not available in the office, in their office, but he has given the person who is conducted, and he says that at that point of time when it is sought to be terminated even in 1995, then says that point of time managing to was not, and then it was expired. So no actions was in the proper, and it was null and void. So this was the this was the
just a moment, Mr.
My Lord, this is not the part of the pleadings which was given to us and on which I had sought for the addition for the affidavit to be filed, my Lord. This is not part of the writ.
Oh, it's the part of the
No, my Lord.
It is in my additional affidavit I have given.
This is not part of the writ petition which my...
No, but he said...
Additional affidavit I have given the copy.
Because these are the documents which he is bringing at the moment. If it is not part of the pleadings, my Lord, we don't have the chance to review it.
Exactly, but he said it has been filed in his additional affidavit.
Additional affidavit I have given, page number 32. Annex A9, additional page number 32. It is clearly written here. Additional affidavit I have to see then. Additional affidavit.
What is the date? There are hundreds of affidavits.
Sorry, my Lord. Maybe. Because if it is not part of the...
Naturally, Mr. Devnar will not be so foolish.
Because subsequent affidavits, government official will have no chance to respond to it.
No.
If it is not made official part
See,
of the writ,
if it has been filed as an additional affidavit, copy must have been given to you. You have the liberty to file a rejoinder to that. So if you have filed the rejoinder, it will be on record.
no,
If you
I
have,
have never filed any rejoinder.
then the,
Because even the additional affidavit copy I don't have. My
how can it be? How can it be? At this point of time, you say you don't have a copy of the additional affidavit. Where is it, Mr. Which date you have filed the additional affidavit?
We can check from the record if I have received it.
Yes, that's what.
So if it is there, if my signature is anywhere there, then I don't have anything to dispute. But if it is filed
But
without my...
no, it should be in your records, Mr. Sir. You don't have a copy of the.
Because he is saying, it seems like some government official is making some statement, and if it is not within the knowledge of my director or any SDSEO, so
This is a letter addressed to DSEO.
so I don't have a copy of it. I cannot ask.
Yes, yes.
That is what my Lord.
Mr. Devra, please check. It must have been.
It is in 16 November
Is it affidavit
2019.
or it is application?
Additional affidavit.
Be-
Additional affidavit. This 16 November 2019.
16 November
16 November 2019.
Yes, Your Lordship.
There's nothing in there.
No, file, Your Lordship.
You filed, we don't know.
It's not here.
We have 21st November 2019 an application for release regular salary. That is I have.
No, it's not. The last affidavit that was filed before this court was in 2017.
2019, Your Lordship.
There's no affidavit of 2019.
I'm having this copy here with me.
Of course, we have filed a affidavit in opposition to the by respondent on behalf of the school.
May I just check, Your Lordship?
16/11/2019. Is it?
16/11/2019.
Huh? So I've given its affidavit in opposition to that also.
Oh, you're filing a miscase.
This is miscase 267.
Yes, 267.
We have given a reply to that.
Where is your reply? It's not here.
We have filed on 29/11/2019, Your Honor.
Okay.
29/11. Application number T2C. Application by the read petitioner directing to disbursement of salary.
No, this is additional documents for the purpose of hearing this read petition also, please to proceed.
So, disbursement of salary, you have made a prayer. Better reply this into issue to Janina.
This is additional documents to take into record, you will see.
Regender by petitioner. Position to regender of this after. For delay, affidavit in opposition, the number of first affidavit in opposition.
अपनी miscase no.
वो तो बड़ा फाइल है
According to my counter affidavit, my lord, the position of the writ petitioner is only as a additional science teacher, and if that is agreeable by my fellow colleague of the school managing committee, then the position of the writ petitioner is well established that he is nothing but the additional science teacher. He cannot demand the salary of a regular science teacher. So if that is an admitted position, then we can proceed. Otherwise, my lord, if the dispute is not clarified, my lord, and if it is not made in the writ petition, my lord, and we don't have a chance to refute whatever is bringing the additional documents, my lord, it will not be fair, my lord.
I don't know, so many things have transpired here. So many miscases have been filed. This miscase for release of your regular salary.
This is subsequently it is come up.
That is what? This is subsequent. This is 2019. And then this is a reply. This is an affidavit to your application.
not decided then. How will bring the
See, as Mr. Devnath has submitted,
My lord.
the prayer in the petition is simply for release of his
Arrears salary.
arrears salary. That's all.
And
There is no issue of him being regular, irregular,
Correct,
not being in the sanction post or outside sanction post. There's no issue on that.
No, but the thing is that, my lord, if the order is not clear whether he will be entitled to claim as a regular science teacher or an additional science teacher, the defense of the monetary defense will be huge, my lord. So some teachers, even some writ petitions, they have obtained a benefit because when the order of the court goes in a vague manner, my lord, the writ petitioner sometimes make the official understand that he is entitled to be a...
No, Mr. Sengupta,
My lord.
the petitioner, rather Mr. Devnath has referred to that paragraph 12. So
Paragraph 12, I have given...
His claim is confined only to the amount set in.
Only this paragraph 12.
Then it is up to the managing committee, my lord, who will be in a better position to reply regarding the salary, my lord. If they are entitled, if they are paid or not.
His salary is to be paid by managing committee,
Yes, ma'am.
not by government.
The amount has gone from the government to managing committee.
We do not
And
give
as
the
per this
salary
order.
to the teacher directly, my lord. It is given to the school in the name of the school. From the school, managing committee, as per the entitlement, they. In para 9, my lord, I have stated in my page 11, my lord, that for the period 1/6/2009 to February 2015, that is for 69 months, the writ petitioner has received salary from the office of the DSC of Surat, and his dues from 2015 onwards is receivable as per regulation from the school itself. So there we are not taking any other stand, we are taking that from the school since 2015. And the writ petition was filed in the month of month of March, April 2015, my lord. And till that, the salary was already cleared. So thereafter, whatever has accrued, my lord, the managing committee will be in a better position to explain what is entitlement.
So this is your claim?
This is my claim.
And your claim is?
And my claim based on the order passed by the government from time to time and which stands in my name.
Yes.
I am only for this LOC. I am not coming for any other matters.
So now what is the stand of the managing committee?
There's a big history, Your Lordship. First of all, we have filed our affidavit in opposition after receiving the writ petition. On 14/9/2015, affidavit in opposition. There we have stated, Your Lordship, before I step in, Your Lordship, I beg to submit that the present writ petitioner has filed a number of writ petitions. This is the third one on the same subject. Third one. First one is 168 of SH of 2002, being contested by Your Lordship's present private respondent, number 12, Ismatara Rahman, by a similar writ petition, bearing number 185 of 2000, SH of 2002. The matter has travelled to division bench, and again, lastly, the division bench said, remanding the matter to the learned single judge that this should be expeditiously disposed of. The matter ultimately came. We are thankful that the single judge, who happens to be the Chief Justice of Honorable Supreme Court, we are proud of him, And that case was, both the cases was clubbed together and decided by its order dated 26/3 probably. Lordship will find this order is there.
28.3.
We have given
28.3.
Which you have annexed in your affidavit.
Yes.
Lordship, it is
I
given.
What page?
Page, I am just. Lordship, I have given a written synopsis of my submission. There I have very particular, no? Inquiry petition. Lordship, let us go to the page 33 of the writ petition. I think I have not given because I have banked up on their document. Yes, Lordship. Page 32 starts from page 32.
Yes.
Now, if your Lordship goes through the contents of the order sheet, it will reveal that the Honorable Single Judge has in paragraph number 5 of it, if I am allowed to read paragraph number 5, it will give your Lordship the total glimpse of the fact. Admitted, Lordship, paragraph in our page 4, paragraph 35. Yeah, page 35.
Page 35?
Page 35, paragraph 5.
Paragraph 5.
5, in our page 4.
Yes.
The last it goes, admittedly there is one sanctioned post of regular science teacher in the school in question, and the school authorities have created additional post with their own sources. As one post of regular science teacher has been sanctioned for the school, naturally the grant will be paid by the state will be in respect of the said one post. Initially, the petitioner in WPC number 168 of 2002 was appointed in the said post. His appointment was duly approved. Thereafter, on 15/3/1995, the service of the said petitioner, the right petitioner here, Your Lordship,
Yes, sir.
was terminated, and in his place, one Samir Raza, was appointed as the regular science teacher. The aforesaid decision of the managing committee was approved by the inspector of schools on 26/6/1995. After S. Raza relinquished the post sometime in the year 1997, the managing committee desired to continue with the service of the petitioner once again. In this regard, had written to the state authority to sanction the grants in the name of the writ petitioner WPC number 168/2002. Grants were accordingly sanctioned in the name of the aforesaid petitioner. The aforesaid situation should have been allowed to continue. However, on 17/11/1998, the managing committee took the decision to appoint the writ petitioner number 185 of SH of 2002. That is your number 12 of the present writ petition respondent, number 12. In the very same post against the petitioner was serving, was receiving the science grant. Same post against which petitioner was receiving the science grant. Kindly see, Lordship, that was in between what happened on that occasion. School was not represented, what I have gone through. I have come entered later part. So many things remain. It will reflect. The aforesaid resolution of the managing committee was strangely approved by the school inspector of school on 23/12/99. The communication dated 14/5/2002, Annexure 4 of the writ petition of 185 of SH of 2002 would show that the managing committee of the school had requested the inspector of schools by letter dated 8/4/2002 to henceforth sanction the science grant in the name of the petitioner of 185. means this respondent number 12. While the aforesaid developments were going on, the very same managing committee sought termination of service of both the petitioners by issuing two separate communications, annexure number 1 to WS 168, WPC 168 2002 and 14/5/2002, annexure 4 of WPC number 185/86. By these two letters, they said that your service, because they are all quarreling, service not only required. The school cannot.
So the school has terminated the services of both.
Yes, they said your service is no longer required. Now, neither the action of the inspector of the schools accordingly, as we find, your lordship, the Honorable Court has referred to those two letters. For that, they have come before the Honorable Court. Neither the action of the inspector of the school in accordance approval to the appointment of two persons against one post can be understood, nor has the action of the managing committee in proposing to terminate the services of both the petitioners been explained to the government, to the court, sorry, lordship, to the court. The writ petitioner in both the sets of writ petition have been working for long. The writ petitioner in WPC number 168 of 2002 from the year 1994 with a break between the year 1995 and 1997 and thereafter till date. The writ petitioner of 185 SH of 2002 has been working since 17/11/99 after her appointment, which was made following the norms in force. Both the petitioners have been working against one post. The aforesaid anomalous situation has been largely created by the action of the inspector of the schools in accordance with his approval to both the sets of appointment. The said action remain unexplained before the court, as no affidavit has been filed on behalf of the official respondents in either of the cases. Number 7, that is most important, lordship. In such a situation, I am of the view that the only possible remedy to the situation would be a direction to the concerned authority in the state government to sanction a second post of science teacher for the school in question, so that the writ petitioners in both the cases can be suitably accommodated and the salaries, etc., as may be due to them can be paid without any difficulty. Though creation of posts is primarily the executive function as such, and such directions are only rarely issued by the court, in the present case, resort to such an extraordinary step has been made as the present impasse which has necessitated such a direction has been occasioned by the action of the jurisdictional inspector of the school, as has been noticed above. The above direction of this this court will now be complied with by the concerned authorities in the state government as expeditiously as possible. Both the writ petitions shall stand closed, answered in terms of the above direction. The copy of this order may be furnished to Mr. S. Swan, learned government advocate, as prayed for. This is, lordship, the order. Now, as I have at the very outset submitted, that after the present position, the matter has been decided between the parties, and therefore the subsequent...
Just a moment.
Lordship.
After this order was passed,
yes,
direction rather,
lordship,
the state government has sanctioned.
Yes, I'm coming, lordship. I'm coming to that again. Let me orally submit, because I have got, if I refer the files, it may delay the matter, but it's there inside. So, when that was given, the state government went on appeal. But the learned appellate court did not accept the contention of the state appellant and dismissed it. So, the division bench said that the state government is to comply with that. So, there was a little gap because procedure is to be followed. Meanwhile, what happened? Your present writ petitioner filed an contempt petition. So when the contempt petition is filed, that is page 52. Yes. Page 52 of the writ petition, Lordship. I am banking upon the petitioner's suggestion. So, when that was the condition, what happened, Lordship? Here is something, some twisting has been made.
Yes.
If your Lordship notices, your Lordship will find that when the matter was moved, it is given an implication that this contempt has been filed by the Madam Ismatar Rahman, not by Imam Abdullah. It is given. Kindly see, Lordship, the order to be complied with in contempt petition is directed, given is in paragraph 7 of this order, such and such, passed by this court in WPC number 185 of 2002. But this is actually filed by 168 of 2000.
Doesn't make any difference.
Whatever, Lordship. So when that was the condition,
it refers to this. It refers to the same impugn order.
Yes. Now what happened when this order was had to be rendered because the learned state government advocate, Mr. Senior Advocate at that time, Mr. Andy Shulai, he has presented a letter addressed to him that the state government has transferred already a post from one school and attached to one school from the Deri Linda Patsala Secondary School. It is in the Happy Valley, I have seen, your Lordship. It is attached with that. And in that case, what happened, Lordship? In view of the above statement, the order of the government has been complied. The order of this has been complied. Order of this court has been complied. Accordingly, the contempt is closed. Now, let us go to the first paragraph, Lordship. As per the direction contained in para number 7 of the aforesaid judgment, the order dated...
You are reading?
I am reading the first paragraph, again this order, Lordship, of 26/6/2009.
Okay.
As per the direction contained in para number 7 of the aforesaid judgment, and the order, the government is to sanction a second post of science teacher in the school in question for the purpose of accommodating the petitioner. Kindly see here, the petitioner here means the contempt petitioner. And this writ petitioner is banking up on that. I have given a shock, that he's giving a misinterpretation that since this is 185, it is written of Mrs. Rahman, so it is for her accommodation, but it is not actually, it is for the accommodating the present writ petitioner.
Okay.
And subsequent letters of the government will also reflect that the government has also intended that the present post transferred should be the writ petitioner, present writ petitioner Abu Abdullah. It is mentioned in the letter that he should be accommodated against that post. Now, when that is the condition, at such a condition, he was again became aggrieved. He has filed another writ petition. Another writ petition. That is again 137, no? 137 of 2010. Again, page number 77, Lordship. Yes. Your Lordship, that is the order, page 77, WPC number 137 SH of 2010. Page 80, no? Lordship, your Lordship's kind attention is drawn to page number 80. there are two writ petitions. One writ petition by the present writ petitioner, which is 137 of 2010. Another writ petition, that is 247 of 2009. It was previously filed by this Matar Rahman, the present, the respondent number 12 here, private respondent number. So this time also, if we go through...
Page 80.
Please, Lordship.
Page 80 is...
this is again the final common order disposed by the second batch of writ petition by Honorable Single Judge.
This is the order dated 14/2.
14/2/2014, Lordship. Lordship, if I am allowed to read, at least for your Lordship's reference, the Learned Counsel, Mr. B.K. Debroy, appearing for on behalf of the petitioner Srimati Matar Rahman, submits that the respondent number 3, the Inspector of Schools, West Garo Hills, Tora, was granted and sanctioned 18,000 in favor of the respondent number 5 as regular science teacher, depriving the petitioner. Hence, this instant writ petition means on her part, the 247 when it came up.
Yes.
In the writ petition number 137, Mr. R. Devnath, Learned Counsel, appearing and for on behalf of the petitioner, Sri Imam Muhammad Abu Alam Abdullah, submits that when he approached this court by way of a writ petition, he was not receiving his salary. However, now he is receiving his salary from the Inspector of Schools, but did not receive the salary for the period below, that is 1/3/97. These are the dates he has given for which he has not got salary. Now, in reply to that, Mr. R. Chaudhary, Learned Counsel, appearing for on behalf of the respondents 9, 10 and 11 in the writ petition 137 of 2010, submits that the facts given in the petition that the petitioner Imam Muhammad Abu Abdullah did not get his salary is not correct. In reply to WPC number 247 of 2009, Mr. R. Chaudhary, Learned Counsel, appearing for on behalf of the respondent number 4, submits that he has no objection to the petition filed by the petitioner. The Learned Counsel, Mr. H. Abraham, appearing for and on behalf of the respondent, must be it is government respondent, state respondents, that the due amount to the teachers and petitioners have already been sanctioned, and the money is lying with the account of the school respondent. And after hearing the submissions submitted by the Learned Counsel at bar, I am of the opinion that the matter can be disposed of with the following direction. The state respondents and the school respondent are directed to clear the dues of both the petitioners as per their entitlement in accordance with rules, and with this observation and direction, these instant writ petitions are allowed by this common order and stands disposed of. So whatever, Lordship, we have in consultation with the Inspector of Schools, because the direction was to the state respondents and the school as well, we have found out their entitlement and paid the amount. And the amount which your humble, the respondent 12 is entitled, we paid to her. And an amount of 37,000 something we have offered to him, you take it. He did not take it. He did not take it. Now, when he did not take it, rather he filed a contempt petition that we have not obliged, have not complied with the Honorable Court's order. Then we have filed a show cause to that, and we have said that we have offered to him, but he is not accepting. Our system is this, Lordship, that we now not giving the salary in cash or check in the hand. We have requested all the teachers, give your state bank account number and we will transfer your respective amount to your bank account, and you will simply sign the acquittance roll. It will automatically go to here. If anything, you may complain to us. Now, let us go to page 82, Lordship. I have not come to my affidavit, etc. I am just now dealing with the writ petitioner's own petition, giving the in short, Lordship, when the matter came up, the Honorable Chief Justice was, page 86, Lordship. 85. Page 85, Lordship. I have been asked, Mr. Chaudhary, why you are not paying his salary. We said, Lordship, there is no question of not paying him salary. We have given him, but he is not accepting. Have you sent it? I said, no, we have the process that I have just submitted, Lordship. I have explained to the Honorable Court. Then he said, you do one thing, you prepare a draft and give it to submit it to the registry. So I at once instructed the school, you prepare a State Bank draft, and it has been deposited in the registry. But I think not yet even collected. My friend can. Now, when the matter was going on, the counsel for the present writ petitioner again crying, I am not getting my, as per the Honorable Court's direction, the last order of 14-2 of 2000, so I am not getting. Then the Honorable Judge was pleased to say that if it is that, you go and file your appropriate case. Then he has filed this case. This third batch of writ petition. Now, third batch of writ petition, he is making submission that he is not getting, but all the money he got during the last, I have submitted 9 lakhs amount, he has received, and we have in our affidavit, we have given that we have paid the amount, and there was the last direction that my friend is to file an affidavit that I have received. But we have given the receipt, etc., utilization certificate, everything in our affidavit in reply in this case that nothing is pending. He is getting his salary now. So, as he was crying in the writ petition before your Lordship that he is not getting his salary is a false statement. It is not correct. He is getting his salary. But his ego is here. Now, coming to this point, that has been already settled by the first batch of writ. Already settled. That I am to get my removal from service was illegal when I was removed in 1995 from March. I am coming to this. Now I am coming to my affidavit in opposition, Lordship, which I filed on 14/9/2015, Lordship. Kindly allow me to proceed. Lordship, if Lordship, I have got a written argument, I have submitted long back.
That will come later.
All right.
First, you say what you have to say in your.
Yes, Lordship. Lordship, got my affidavit in opposition?
Yes.
That is in page number 2, it starts, fact behind the case.
Yes.
Page number 2, paragraph 3, Lordship. The writ petition filed by the petitioner is a misconceived one. In this regard, it is most humbly and respectfully submitted here to say that the writ petitioner conveniently suppressed the material facts. It is a fact that the writ petitioner was appointed as a science teacher purely on temporary basis, subject to termination without assigning any reason, with effect from 21/9/1994, and continued to work as such a science teacher till 28/2/1995 against ad hoc grant for the science teacher, and subsequently his service was terminated as per the then managing committee resolution number 1 dated 15/3/1995, which was approved by the then inspector of schools, West Garo Hills, Tura, by his memo number SWG MC such and such, dated 26/6/1995. However, it was proposed from the school authority that if the writ petitioner was at all interested to work as additional science teacher with a sum of rupees 1,000. Lordship, at that point of time, 1,000 had got some value. 1,000 only per month as remuneration with effect from 1/3/1995. He may work so, and the writ petitioner accepted the proposal and worked as additional science teacher till 29/2/1996 on the same salary, and from 1/3/1996 to 28/2/1997 at the rate of rupees 1,500 only per month. Now, what I was submitting, Lordship, that at the very beginning, earlier on my short submission, that this writ petition, present writ petition, it is barred by estoppel. Once the writ petitioner has accepted the fact as submitted here as fait accompli and acted and taken salary, Lordship, attention is drawn to page 39 of the school's respondent school's affidavit in opposition, page 39, which is the acquittance role of teachers. Now, Your Honor, Lordship will find I have given all the periods for which he worked as additional science teacher, and he has accepted on revenue stamp. So after accepting the condition, does he's having any right to file any writ petition? Is he not barred under the principle of estoppel? This is the first submission. Second plea on my behalf. First one is that it is barred by res judicata also, because twice the Honorable Court, single judge has decided the fate of the present writ petitioner.
Yes.
As such, the writ petition is liable to be dismissed. Not only on that ground, Lordship will find that when 3 batches of writ petitions has been filed and been contested, it means that he is not ready to even accept the findings and decision given by the Honorable Division Single Bench twice. So, it is completely a disputed matter, because this Honorable Court cannot put the man into the dock and cross-examine this and that. So, in that circumstances, my humble submission is this petition should be again dismissed. That disputed question cannot be assailed in the writ petition. And in my written argument, I have given 2 Honorable Supreme Court's ruling. If it is misplaced, Your Lordship, because I submitted as far back in 2019. If it is misplaced, I will give a second set. I have come with it.
Please.
So, this is the condition, Lordship. So, when that was the condition, let me proceed, Lordship, then again. Then it is that I am coming in page number 3 of my affidavit in opposition. That it would be appropriate to mention here that the writ petitioner's service was again terminated as additional science teacher with effect from 31/3/1998, while during the period of 1/3/1997 to 1/3/1998, the writ petitioner refused to accept his salary at the same rate. Your Honor, Lordship, I will produce before the Honorable Court that the writ petitioner, once he has been said that your service is no longer required, by force he is to enter in the school, is to sign the attendance register, and he was doing politics with the what is happening in that our area. So in that case, Your Honor, Lordship will understand what is the condition he made in the school environment. That salary rate a different pretext. The amount of 19,500 only for 13 months has been paid to the writ petitioner along with dues for the period 1/3/2009. Now it is coming, Lordship, 1/3/2009 is the salary when the new post was transferred to that school, and his salary is accumulated against that transfer post against which he has been attached. Now, with dues from the period from 1/3/2019 to 1st March 2009 to 31st 2009 being 18,000, only at the rate of 6,000, only per month, being the entitled dues by State Bank of India, Rajawala State Bank branch, State Bank draft in the registry of the Honorable Court as per order dated 10/4/2015 as passed by the as passed in the contempt case number 3 of 2015 out of the common judgment and order passed on 14/2/2014 as passed by the Honorable High Court in WPC number 247 of 2009 and 137 of 2010, as the writ petitioner refused to accept the said dues from the school, although he was formally requested by letter number such and such dated 30/3/2015 in compliance of the Honorable High Court's order dated 14/2/2014, Lordship. That I have already submitted. It requests to be submitted here to state that the present writ petition is the third in number to the best knowledge of this answering respondent, and therefore that he had filed earlier a writ petition being first one by 168 of 2002, and there was another 185 of 2002, and by another science teacher named Srimati Ismatra Rahman of the same school, claiming that she is the regular science teacher with effect from 17/11/1999, and by order dated 28/3/2006, the said two writ petitions were disposed of by the Shillong bench of the Honorable Guwahati High Court, High Court of Assam, Nagaland, such and such, by order dated 28/3/2006, passed in common, wherein the Honorable Single Judge had directed the state respondents. That so, Lordship, I have already submitted, Lordship. The judgment is available as Annexure 4 at page number 32 of the present writ petition. That may kindly be perused, and in the esteemed judgment, nowhere it is observed in specific words out of the two contending that writ petitioners who is the regular science teacher and who has been working as additional science teacher on lump sum salary. But the writ petitioner here before your Lordship is banking. Somewhere your Lordship will note that the Honorable Single Judge in the first batch of writ adjust him as the regular science teacher. So what a misleading statement he was making continuously before the Honorable Court. Now, para number 3.1. The present writ petition again filed another writ petition 137 that I have submitted, your Lordship. It is gone. The Srimati Ismatra Rahman, again this that I have already completed. That has gone. 3.2, that is also already covered, Lordship. Another peculiar circumstances created. Yes. Your Lordship will find if the writ petitioner was aggrieved by the Honorable Single Judge's order, the law has permitted him to go for a writ appeal. He did not necessarily get appeal. Rather, in case of second writ, 137 of 2010, he filed a review petition before the Honorable Single Judge, and the Honorable Single Judge was displeased to note that it is not a review petition, it is rather an appeal. However, he has considered that no review is required. So his review petition has been dismissed. Now again it is barred. Kindly see, on the same matter. This is if we take review as another batch of legal action, then this is the fourth. This one is the fourth. So all these are, again I am proceeding, Lordship. This will reflect, Lordship, I am just submitting, referring Lordship's attention to page number 7 of my affidavit of opposition.
Para
1.3.4. Before that, Lordship, I will just Lordship's attention draw to report at page number 66 of my affidavit of opposition. That will make everything clear. That is a report by the Additional Director of School Education and Literacy, Tura. Now our government, state government has created this additional post has been transferred to Tura, covering the entire Garo Hills, 4 or 5 districts there. So the government has entrusted this officer to make an inquiry whether repeatedly this present petitioner is saying he is the science teacher, he is the science teacher. So this highest officer of the state, maybe in the additional cadre, he has given his findings, and if I am allowed to read, he has pointed out 2 things.
No, this you're reading the.
I am reading this Annexure F at page 66 of my affidavit in
It's not a
opposition.
report, this is an order.
It is an order. This is an order of the additional deputy, additional director of the school.
Just now you're saying report.
Order number 88.
Yes.
It goes like that. Under the authority conveyed by the Director of School Education and Literacy, Meghalaya, Shillong, by this letter number 15 May 2012, directing the undersigned to examine the representation from the Secretary Holiday Secondary School regarding the prayer for restoration of financial power of the Managing Committee for drawal of disbursement of science grant to the school science teacher, and thereupon to pass an order accordingly to restore the normal activity of the school managing committee under the undersigned, after thoroughly examining all the relevant papers, is pleased to state as that. What happened, Lordship, here? Lordship, my friend might have drawn your Lordship's attention that private respondent number 12 has been appointed by the committee when it was not in effect. Very nicely he has proceeded, but he has no knowledge that when that was the condition, the school committee assailed the order of the inspector of schools to Guwahati High Court, and it got its stayed. As soon as it is stayed, means it revived, the order of revived. And that point of time, the committee make an advertisement and appointed the private respondent number 12, who was found to be having all the qualifications and experience, everything, and her appointment is regularized by approval from the government. I do remember, Lordship, on the last 11th, Lordship was pleased to direct us regarding the approval of the appointment of Samiur Raza by the whether I said submitted that it is the approval is made on the resolution submitted, giving the left side on the margin. Now, what is the real position after going through this matter? I have found that the school inspector at the district level does not do anything of his own. Whatever it comes, he sends to the director and obtains approval, and it communicates then to the school. So, Your Lordship, I have annexed in my one affidavit in opposition or in the additional affidavit the sanction by the director of Samiur Raza. Once the appointment of Samiur Raza has been duly approved in place of the present read petitioner, where is he stand that he is a regular science teacher? No more. He is no more the science teacher. So, let me... Application for release. So many papers, Lordship. Otherwise also I have come, they have sent me by post, over WhatsApp, that approval letter. But after consulting the replies, I found that it is already we have submitted. Let me see what. I think I can.
This is with regard to the respondent 12.
Yes, Lordship.
This is with regard to respondent 12.
Yes, Lordship. I have given it.
This is saying...
Please wait. Please wait.
Yes, Raja is not the respondent here.
Who?
Yes, Raja.
please wait, I am not corresponding. Raja is no longer in service. He is already gone from your school. Now, I have submitted this approval letter along with my affidavit of facts making clarification by the respondent number 10 on his behalf and on behalf of respondent number 9 and 10, 9 and 11 to ascertain matter as raised by the writ petitioner in respect of rejoinder affidavit dated 26/9/2000 to the affidavit in opposition of the said. That is filed on 8/11/2016, Lordship.
Page?
8/11/2016.
Where is the...
Page. Page is, Lordship, 22.
22?
22. I think this is the order, Lordship. Approval is hereby accorded to the appointment of Sri Samir Raza.
Just a moment. 22? Okay, sorry. 22 of your affidavit?
Affidavit dated, submitted on 8/11/2016.
Just a minute.
This is affidavit of facts, Lordship, making clarification. That is against their affidavit, rejoinder affidavit. 26/9, they made a rejoinder affidavit. Against that, with the permission of the court, this affidavit is filed as affidavit of facts, clarifying the position.
Paragraph?
Not paragraph, it is an order, page number 22, annexure 1A. 1 is the order by which he was removed from service after the resolution of the managing committee approved by the inspector of schools. And the approval, I think Lordship has got it.
Yes. Order dated?
That is order dated 21st November 1995.
So this Samir
Reza, BSc, a science teacher in the Holidayganj Government Aided High School, West Karo Hills, with effect from 1/3/1995.
So he was appointed in place of the petitioner?
Petitioner was only appointed as an ad hoc, and he was ultimately removed removed for his different activities, Lordship. That is also does not look nice to place in this court, before the court. And due to other reasons also, there was a advertisement. It was number of applicants were there. Out of that, Samir Raza was found to be the qualified candidate.
So now, in place of this Samir Raza, he has since demitted office?
He has demitted his office because he got a better chance.
Okay.
In the regular, aided school, better salary.
So in his place, the respondent 12 has come?
In his place, after he retired, then what happened? The school students cannot suffer because the writ petitioner already accepted as a fait accompli that he will work as an additional science teacher. So he's been said, you do it. Because additional, in the form of additional, he has accepted. And he has been asked that you do it. You do the, till the alternative is done. So in 1999, again another advertisement was made, and respondent number 12, private respondent, was appointed. And meanwhile, he has made a number of irregularities. Irregularities was that he, along with a lawyer, one Mr. Khan, who was also the upper primary school's headmaster, came to the directorate and said that I am the regular science teacher, so a grant may be given in my name. So ex facie, the directorate has given in his name. But thereafter, when this, and that amount was, he has taken from the inspector of schools.
Okay.
That salary is taken from inspector of schools. Now, when we have made a complaint to the department, and what I have just referred to, additional director's findings, the school is aggrieved that the school inspector is paying salary. And your lordship will find, we have given in one of our affidavits that addressing a letter to Mr. Abu Abdullah here, that your claim that you are wanting that your salary should be directly given to the school inspector. It cannot be. This directorate never gives any salary to any individual name. It is given in the name of the school. The school knows to whom it is to be paid. So these are there, lordship. If need be, I will come to that level. Now let me finish it, lordship. I am just submitting and trying to satisfy your lordship's query what was made on 11th last. It is there. Now, when I was over that report by the additional order, there is order 88. That is annexure F of the affidavit of opposition, page 66. Now, let me read what the officer found. As per letter dated, I'm reading para number 1, lordship.
Page?
This order 88, annexure F of the affidavit in opposition, first affidavit in opposition.
Yes.
I read up to that how he has dealt with. As per letter dated DHS such and such, dated 17 April 2002, from the then Deputy Director of Higher and Technical Education, Meghalaya, Shillong, it was alleged that the science grant of the school, which was released with effect from 1/3/2001 to 28/2/2002, in the name of the science teacher Imam Muhammad Abu Abdullah, was allowed by the then Inspector of School, West Garo Hills, Tura, to be drawn by the then managing committee secretary of the school said school and not paid to the science teacher and misutilized by the managing committee secretary, and the inspector of school Tura was directed to recover the amount from the MC secretary, amount not mentioned, Sri K.R. Khan, that is the lawyer, gentleman lawyer Khan, advocate, and the president, the then president of the Holiday-Ganj Deficit Upper Primary School has been mentioned as the complainant. As per letter such and such, the Director of Higher Secondary Education, it is alleged that the MC of the Holiday-Ganj School approved by the then Inspector of Schools Tura by letter number such and such, dated 18/1/2002, for the period of 18/1/2002 to 17/1/2005 was constituted without holding any general meeting. It was also alleged that the then Inspector of School Tura allowed the science grant due to Imam Abdullah to be drawn by the secretary of the new MC, which was unpaid to the teacher and misutilized, and thereby the above managing committee MC was kept under suspension by the Director of Higher and Technical Education pending submission of inquiry report by the then Inspector of School Tura. The Sri K.R. Rahman, advocate and then president of the Holiday-Ganj Deficit School, is mentioned as the main complainant. As per letter such and such from the then inspector of, these are the reference, lordship. Then as per letter such and such, let me find the findings, lordship. Number 4 paragraph, as per letter number such and such, 17 May 2002, the then inspector of school Tura submitted the report in detail on the matter relating to Imam Muhammad Abu Abdullah and his claim as science teacher and science grant. It was reported that Sri Imam Muhammad Abu Abdullah was finally found established that he was already terminated on 15/3/1995 as submitted by record enforced by the order number 12/6/2000, and the then Inspector of School Tura recommended that all grants drawn illegally by the said science teacher mentioned above from 1988-99 onwards may be recovered in the public interest. Kindly see what amount he has in the absence of the committee till the High Court has stayed the order and restored the position. The writ petitioner took the help of this K.R. Khan. Therefore, the inspector of schools ordered that he is to return the amount. And there was also, your lordship will find there is a letter from the school headmaster cum secretary that you are to refund the amount what you have unauthorizedly drawn. You are not the science teacher. Now, let us come to the observation of what he made, lordship, in para number 67 in our page 2. After careful perusal of all records, the undersigned is pleased to observe a general meeting of the holiday going government aided secondary school was actually held on 31st 12/2001 at 2 p.m. in the school premises, and selection of MC was made in the presence of the public and recommended approval by the then local MLA and the then inspector of schools by such as 1801/2002 approved the above MC. So the continuation of this managing committee was valid.
Or continuation?
Was valid.
Constitution or continuation?
Constitution, decision of continuation.
The Constitution. So the constitution of this managing committee was valid and done as per existing government rules. So that is gone, lordship, what the writ petitioner hesitated that it is gone. Now comes the above MC had no time been suspended or dissolved, and the functioned with full power. Then comes point 3. The then science teacher Sri Imam Abdullah was terminated from service on 15/3/1995, substantiated by records enforced by the order number 12/6/2000, and his claim for science teacher after that period was illegal, but it appears that he managed to mislead the education authorities into drawing and disbursing the science grant to himself with the help of Sri K.R. Khan, advocate. Now, recommendation is that the undersigned has taken into consideration the following points as per section 2, chapter 3 of Assam Education Department Rules and Orders, volume such and such. The Constitution of Managing Committee of the Government School and Middle School approved by the Inspector of School is the sole authority for management of the management or administration of that particular school, and the state government is concerned only with the system of funding the ad hoc grants. Based on the performance of the teacher, the managing committee has every right to take decision. Only approval is to be given by the inspector of the school concerned. Now, therefore, the undersigned, after having thoroughly examined the matter, is pleased to order to the effect that the normal activity of the managing committee of the holiday going government aided school be restored, including restoration of financial power for withdrawal and disbursement of all grants and science grants to the science teacher of that school in suppression of all previous orders given by the educational authorities concerned. Copy to all the concerned Director of Education, District School Education Officer, the concerned that are given. Now, after that findings and report of the the highest officer, I should say, additional director, does anything remains what the writ petitioner has complained against the school, that school has made. Lordship, I have forgotten, the file has been taken. The then secretary, I had to file a writ petition against the state government when the state government said that the school inspector will pay the salary of science teacher, this and that. And at that point of time, this finding was made. After getting the writ petition, the state government authorized him to make an inquiry and he made the report. And that report, when I produced before the Honorable Single Judge, the writ was disposed of in our favor, the Secretary's favor, Lordship. So this is the matter, Lordship. Now comes, kindly see, Lordship, page 69, next page. The letter is by the Director of School Education and Literacy, Meghalaya. Payment of grant in aid directly to teacher. I think Lordship got it.
Yeah.
Payment of teacher. With reference to your representation dated 24 September 2012, this is to inform you the government does not pay any grant in aid to any individual nor any teacher. The grant in aid is paid to the school and the name of the school management committee as per regulation of the grant in aid and not in the name of any individual. Please also note, Treasury has also no power to pass bill submitted in the name of the teacher. Hence, you should contact your school managing committee. Can you see that?
This was issued to him in response to what?
This was, he was making that the school is not paying my salary, this and that. So I am the regular science teacher. Grants are given in my name. So on that, when he was, complaining to the inspector of schools, then probably inspector of schools taken resort to. But and for that writ petition, the secretary filed, as I just submitted, Lordship, and this officer, in the capacity of additional director stationed in Tura, made an inspection, given his report, and it is by this order the power has been restored to the school, even to disbursement of the salary to the appropriate science teacher, and also this letter by the director himself to the writ petitioner that your claim and request cannot be entertained. You go and contract and take your salary from the school. That is the question, Lordship. Now comes, it's a big history, Lordship. If your Lordship goes through other this thing I've orally I've placed. This thing I've already submitted, Lordship. Now comes paragraph affidavit of opposition, running page number 11, Lordship. 11, Lordship. Affidavit of opposition, the first one which we filed in 14th September 2015. Well, somewhere I may skip, Lordship, but important matter I am just referring. I think Lordship has found page number 11.
This is filed by?
This is filed by the school.
Not respondent.
By the secretary of the school.
Respondent to us.
No, this is respondent 10, secretary of the managing committee on his behalf and also on behalf of 9 and 11. School and the headmaster.
15-9.
Lordship?
You are referring to the affidavit
14-9. Affidavit in opposition.
14-9 is the same one that you have.
Oh, same one, Lordship.
No, just one.
This is against this present writ petition, 132 of 2015. But Lordship, page number 11.
This one.
This is the body of the affidavit in opposition, not annexure.
Paragraph?
I'm coming to sub-paragraph. last paragraph of that piece. That thing I have already submitted, Lordship. It will be repetition and it will burden you
It
unnecessarily.
requires to be mentioned.
Yes, it requires to be mentioned, Lordship. It starts.
Okay.
Got it, Lordship?
Just a moment.
Should I write?
Yes.
Read? Lordship?
Please. Para 4.
Actually, para 4. Para 4, last paragraph I'm starting.
Yes.
That, para 1 and 2 I've already covered, Lordship. This is a new episode, therefore
Yes.
I'm submitting.
Please.
Yes. It requests to be mentioned here that one Mr. S. Raza was regular science teacher for the school on being appointed with effect from 1/3/1995 on regular basis. As regards the question of testimonial dated 29/8/2000, Annexure 11 of the present writ petition, it is humbly submitted here to state that the writ petitioner forced the headmaster to sign the said certificate on being a gentleman. The headmaster had complained to the secretary without taking resort to criminal action by his written complaint dated 29/8/2000 itself, that his signature was obtained forcibly by the writ petitioner. In pursuance of the said complaint, the managing committee of the school by resolution number 1 dated 9/9/2000 re-recognized the certificate dated 29/8/2000, and the then secretary of the school by his order number such and such dated 9/9/2000 as per the managing committee's resolution declared the certificate dated 29/8/2000 so obtained forcibly by the writ petitioner as invalid, and any use of the same by the writ petitioner shall amount to offence, and directed the headmaster for necessary action to execute the order dated 12/6/2000, and a copy was endorsed to the writ petitioner. Can you see to what extent he went? Now these are the things, Lordship, we have given the resolution copy, etc.
Yes.
Then also that I have orally, number 5, let me, page 13, Lordship.
Page 13.
13. Here, that in reply to paragraph number 3 of the writ petition under reply, this answering respondent 10 humbly and respectfully submits here to state that there arises no question of harassing the teacher of the school like the writ petitioner. Rather, the writ petitioner, being a person arrogant and litigant nature, has been continuously harassing the respondent school for the last 15 years and more by filing writ petitions one after another with writ appeal, review petition, and lastly contempt of court cases, the burden of which the respondent school as a social institution is unable to bear and carry, particularly as it involves huge financial involvement and manpower for follow-up action.
So by saying all these, what do you intend to convey?
By all these, the school likes to bring to the Honorable Court's notice that whatever he has submitted in the or stated, these are not at all correct. In his, that he has been harassed by the school, it is not, rather he is harassing the school. In his non-payment of salary, it is also a false statement. We have given in our affidavit here an affidavit of facts also. And lastly, all the payment 9,99,000 or 90,000, even giving the utilization certificate submitted to the state government, his copy, his signature, everything we have given, and he is now getting his salary regularly. Your Lordship will find that even the state government has given the school warning that if the salary is not given by the not taken by the teacher concerned, refund the money to the state fund. Then we again given him a warning that if you do not do, or once the grant goes back to the state government, it will be difficult for you to survive with your family. To that extent, we requested him. Ultimately, I do not know what a good advice from any source he got. He came and he is accepted. So, he is given, not accepting, coming with a contempt.
Your Lordship,
It is, please, I have not finished.
just one.
Let me finish. I have not yet finished. I have only affidavit, first affidavit, I have not yet finished. Second affidavit, third affidavit, will still go on. It is submitted, now I am going, Lordship, to 5.2. It is submitted here to place on record. The respondent school filed an application, Bhait Miss Case number 134 of 2002 for a Now, he has taken so many pleas, Lordship. So many pleas. A matter which has been settled in 2006 in a writ petition in its earlier stage before different single judge, he is referring it here. So once the thing is already completed, finished, referring the matter again, making it misleading to Honorable Court. Therefore, such a controversial matter, disputed matter, Honorable, the writ court cannot sit our Lordship and decide until the oral evidence is given, cross-examination is there, veracity of the document. These are the things, Lordship. Now, I am trying to skip. It is, again, I am going to 15 paragraph, page 15. It is again a matter that matters much in judicial proceedings, as both the writ petitioners had obtained contradictory interim orders. Lordship, that is also gone, already settled by the first order of the Honorable single judge when it was decided.
Yes.
As per in 2006. But since it is mentioned, I had to touch every paragraph while answering these are all repetition, Lordship. No other alternative way. If I do not meet.
Repetitions are already there, my lord.
Yes.
To this extent, we have already made our case very clear.
I have given para-wise.
Go back to the written argument, my lord. It will help Honorable Court to.
If Lordship,
but the way,
if Lordship
the way the submission is going, you see, it is very confusing.
No,
because
should we break here? Because Lordship, I am going in a decent way to make your Lordship. Let me proceed a little. Little, if your Lordship allows me. Should I do?
We'll take it up next date then.
So I will continue a part hard.
Yeah, we'll give it part hard.
Part.
Because our written arguments are already there.
Maybe.
But I believe Lordship is already clear in mind as to what is the actual position of the writ petitioner, what is the entitlement, if at all, my lord.
Because the school will never do, because to the teacher, it has been told that you are a respectable teacher. We will never make any discrimination.
Fine. Heard. Then a counsel for the petitioner. Also heard Mr. Archival and counsel for the respondent. Your respondent?
9, 10 and 11.
9, 10, 11.
School respondents.
Yeah. 9, 10, 11. Yes, yes. That's okay. As submitted by the parties, this matter is kept part heard for the hearing to continue on the next date fix. This is matter to 1 week.
Much.
Can I go through this with the additional affidavit is there?
Yeah, you go. The court master is there. You can.
Second call, item number 8.
So, Mr. Kaur?
Any date may be fixed, Your Lordship, because already I think time also. 4.
2 weeks then. If I put up to next week, so many cases are there.
Right, Your Lordship. It was already time also, it's 4 o'clock, Your Lordship.
As submitted by the petitioner, this is matter after 2 weeks.
Deeply obliged.
Yes, Mr. Chaudhary, were you there just now?
Sorry, pardon, Lordship.
Were you there just now when the order was passed?
No, Lordship, I just joined.
Okay, so on the prayer of the parties, this matter is adjourned because of time. 2 weeks.
No, but I very well understand, Your Lordship, as per Your Lordship's convenience.
Fine. Thank you.
Deeply obliged.